Today, fresh matters today. Fresh matters.
Your lordship's kind permission.
Withdrawal. You appeal it.
Lordship's kind permission. One matter, my lord, I am representing respondent. Writ appeal is filed by the KPTCL, my lord. Am I audible, my lords?
Yes.
My lord, one matter, my lord, where, my lord, the censure was ordered. During censure, my lord, I approached this honorable court, and this honorable court is pleased to grant me relief, my lord, in a learned single judge order, my lord. The same was challenged by the KPTCL, my lord. My further promotions are, my lord, now, my lord, they have questioned. Lord, there is some urgency, my lord. May I request, my lord, tomorrow or day after, my lords?
Not possible, sir. Yes.
My colleague is there, my lord. He is handing over.
Matter, my lord.
Yes.
Beneficial appeal.
Huh?
Beneficial appeal, my lord. The execution petitioners that they are obtained.
Fresh matter.
To delay to notice hogi.
Huh?
They are proceeding with the execution.
I put it. Yes.
One is the owner appeal in a motor accident, my lord. They are also
Yes.
executing that.
Yes.
Admission matters. Case number 1, Hima L. Kulkarni.
Yes.
Agreed by the order of the learned single judge minutes. Respond number 5 herein. One Rajkumar. He was unauthorizedly absent. He was on a Narega scheme. He was appointed as computer operator, my lord.
Contractual basis.
That was temporary, purely temporary. And on Narega scheme, until the scheme was, it was an understanding that until the scheme was there, he would be appointed and he shall not seek for any permanency also. And he remained unauthorized absent from 2009. He was appointed in 2007. From 9 till 11, he remained absent. Therefore, my lord, for discharging of duties, PDO and there was a resolution to make my party, that is the appellant herein. He was appointed, my lord, in 2011. And his appointment is also approved in the year of 2016, my lords. When these being the facts, my lords, he filed a writ petition before the learned single judge in 2015 without making me party, saying that my representation will be considered because I am already removed. My representation, the symbol, 2015, my lords.
He had filed, earlier he had filed a writ petition.
A writ petition only to consider representation. And, there was a direction to consider representation. Under the garb of consider representation, my lords, a memo is issued to me saying that you have to be removed because he has moved a representation and he has gone to learned single before the High Court and we have to obey the order. There was no such direction to reappoint him or to consider his case for the appointment.
Your appointment also was on.
My appointment is approved and it was by way of resolution, it was appointed and it was also approved in 2016. Lord.
Yes. What happened? What is the finding of the learned single judge?
They say that, my lords, my appointed is tainted with illegality. Therefore, I have to be removed and his services has to be considered. That is illegal.
Contractual basis. What is this?
This should not happen.
As if this is the only, it's a contractual appointment and only for a few days.
Yes.
Then how can you go on making this kind of a representation?
I did not make, my lord. This is response.
Nimdu ashtene.
Nanige remove ಮಾಡ್ತಾ ಇದ್ದಾರೆ. I am working.
Right. The person who was earlier working approached this court.
Yes.
There was a direction. And therefore they have reinstated him back.
They did
and
not
that again will be for a limited period only.
They did not reinstate me.
Then
I was already discharging my duties. Therefore, they said they did not remove
to
me.
make way for him.
Yes.
You are asked to stop you.
I approach this court, my lord. There is a stay order.
Thing in this.
My lordship may kindly see, my lords.
List it after vacation.
Please.
Yes.
CL number 2, DP Ambekar.
Connected matter, Mukesh has been issued.
Huh?
Already in connected matter, the KPTCL is put up there. Good for partition. Notice has to be issued. First appeal.
Please issue madilva innu.
Inna madilla.
It's coming up for first
Coming
time.
up for first time.
KPTCL Ajay Kumar for KPTCL response.
I appear on behalf of Ajay Kumar.
Huh?
I appear on behalf of.
Respond number 1.
Yes, ma'am. Only.
Only for respond.
Only for respond number 1.
Learned Counsel Shri Ajay Kumar AK has entered appearance for respond number 1. Idenidu CP in number so and so.
Caveat petition.
Caveat petition.
Caveat petition number.
In RFA.
Connected matter ನಲ್ಲಿ ಒಂದೇ caveat ಹಾಕಿದ್ರು. That was put up in another connected matter. Copy of the caveat is put up in this.
So in the other RFA, the other parties are served.
ಇನ್ನಾಗಿಲ್ಲ. That is notice issue ಆಗಿದೆ ಅದರಲ್ಲೂ.
ಅದರಲ್ಲೂ notice.
ಅದರಲ್ಲೂ notice
ಅಷ್ಟೇ ಇನ್ನು.
ಅಷ್ಟೇ.
Issue notice to the other respondent. Yes.
Please.
Bill number 3, Ganesh Chandra Kalaburagi.
I am for response 6 time. Discuss. Rest for that.
CL number 3,
Family court matter.
Oh, family court.
Mediation.
The family court granted divorce to the husband.
ನಾವು ಕಳಿಸಿದ್ದ
ಅದು
ಅಥವಾ ಇಟ್ ವಾಸ್ ದೇರ್ ಅರ್ಲಿಯರ್ ಇಲ್ಲ ಇದು March 2024. After that matters come up.
yes.
Matters called out. There is no representation for the appellant. Release this matter after 26.
CL number 4, Babu Rao Mangane.
Suspension of
sentence.
My lord, pass over.
Pass over.
CL number 5, Sparsha Shetty.
I'm appealing for the appellants, my lords.
Yes.
Last time, lordship has directed the management to secure instruction on the vacancy available in the institution. my lord.
Totally, my lords, secured instruction. The college management is also present. Totally, there are 3 posts for the lecturer of education. 2 are filled up by the government.
One is vacant.
1 is vacant. So if government chooses, it's aided post.
An aided post.
Aided post. 1 aided post for a same subject is vacant. So if the government, if it so desires, it can appoint the petitioner, appellant herein.
And it's not reserved.
Not reserved. Well, they have to, whether it is reserved or not, government has to fix it.
What should we dispose of the appeal itself?
It can be disposed of with a direction to the government to consider the appellant to be appointed in the post of this thing under the respondent management.
She continues to work.
Pardon me?
She continues to work in your institution.
Yes, yes, my lords. From 1993 till today, my lords. Another 4 years left for retirement, my lords.
So as on today, she is not working.
She is not working.
Part time ಮಾಡ್ತಿದ್ದಾರೆ.
She is
ಅದೇ part time ಮಾಡ್ತದೆ.
Part time ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
She is working.
working, my lords. Yes, my lords. My lords, kindly pass over, my lords. Senior will
We are allowing your appeal.
kindly pass over, my lords.
We are allowing your appeal.
Yes, my lords. Much old.
ಸಾಮಾನ್ಯಕ್ಕೆ vacant ಇದೆ.
Huh?
General category is vacant.
Vacant.
General category ಇದ್ರೆ that rule applies automatically.
The appellant is aggrieved of the impugned order passed by the learned single judge in WP number 203381 of 2018 dated 1st of June 2024. Now, for the sake of brevity, for the sake of convenience, the parties shall be referred to as per their rank before the learned single judge. Stop. Next para. The petitioner filed a writ petition aggrieved of a recruitment notification dated 26/6/2018 issued by the fifth respondent institution where the petitioner is working on part-time basis, as lecturer in education. Stop. It was contended before the learned single judge that the petitioner has been working in the respondent institution year 1993. Full stop.
General.
Comma on temporary basis. Full stop. The
ಬಂಡಪದ ಬಿಟ್ಟಪ್ಪಿಲ್ಲ ಅಲ್ಲೇ ಮಾಡ್ತೀನಿ ಪಾಸ್ ಅವ್ರ
institution had earlier recommended the name of the petitioner along with others for granting aid in the post of lecturer in education. Full stop. However, the recommendation of the institution was not accepted by the department, comma, on the ground that the post vacant for the subject education is reserved for a scheduled caste candidate. Full stop. Thereafter, the said post was conferred grant in aid, and and another person was appointed to the said post. Full stop. Nevertheless, the petitioner continued to serve on temporary basis, and even till today, she continues to serve in the respondent institution. Full stop. The learned single judge, therefore, held that last sentence, that it was also noticed that the petitioner was beyond the age of appointment as lecturer, and therefore, at any rate, she will not be permitted to raise a challenge to the recruitment notification. Full stop. Next para. Learned senior counsel Shri V. Lakshmi Narayan, appearing for the petition appellant herein, submitted that having regard to the law laid down by the Honorable Supreme Court in the matter of Uma Devi versus State of Karnataka and others, comma, the appellant herein is fully qualified for consideration of regularization of her services, comma, having regard to the admitted fact that the petitioner has been serving in the institution from the year 1993. And even before the apex court passed the judgment in Uma Devi in the year 2006. The appellant has had completed 10 years of uninterrupted service in the institution. Full stop. The learned senior counsel would therefore submit that necessary directions may be given to the respondent authorities to regularize the services of the appellant in the post of lecturer dash education, Full stop. Next para. On the previous occasion, we had directed the respondents to secure instructions as to the number of posts in the institution for the subject dash education and whether there are any vacant posts available. Full stop. Today, learned counsel for the fifth respondent institution submits on instructions that there are totally 3 posts in the subject dash education and 1 post for general category is still available. Full stop.
Aided post, 3 aided posts.
Okay,
Aided, 3 aided posts.
3 aided posts.
Aided posts.
Next para.
And also my submission is if government chooses, it can appoint.
Having regard to the facts narrated herein above, we are of the considered opinion that the appellant is entitled to seek regularization of her services, since she fulfills all the requirements as directed by the Honorable Supreme Court in the case of Uma Devi bracket Supra. Full stop.
Also,
Moreover, the appellant has also crossed the age for seeking direct recruitment, and therefore it is all the more incumbent upon the respondent authorities, more particularly, who is the competent authority? Commissioner,
respondent number
The commissioner, my lords.
2. Commissioner,
commissioner respond to respond to commissioner. Point.
more particularly the second respondent, Commissioner, Department of Collegiate Education.
The respondents, 1 and
Respond number
2, my lords. Respondent 2.
to consider the case of the appellant herein for regularization of our services in the vacant aided post of lecturer dash education. Full stop. Next para. In that view of the matter, the writ appeal stands disposed of with a specific direction to the respondent authorities, more particularly the second respondent, Commissioner, Department of Collegiate Education, to consider the case of the appellant for regularization of services in the vacant aided post of lecturer dash education available in the fifth respondent institution. Full stop. The fifth respondent institution is also hereby directed to forward all necessary information to the Commissioner, Department of Collegiate Education, along with a copy of this order,
Please.
to enable the Commissioner to consider the case of the appellant for regularization, as directed herein above. Full stop. The entire process shall be completed as expeditiously as possible and at any rate within a period of 4 months from the date of receipt of a copy of this order.
Please.
CL number 6, Sudarshanam.
This is the appeal filed against my lord, interim order dated 2/9. Order granted on 2/9/2024. This is the appeal, my lord, against. Lord, hearing, my lord, the notification dated 5/8/2024 issued by the state government. He's been, my lord,
notice order agida. Office objection regarding process fee.
ಅಲ್ಲ ಅದು Lord, we Lord comply with within the Lord during the course of the day. The thing is other side petitioner advocate
Admission
also
ಬಂದು ಹೋಗಿದೆ, we have issued notice.
ಕೊಟ್ಟಿದ್ದೀರಿ Lord. I in fact,
It can't be considered again.
ಅಲ್ಲ, we have given Lord a copy to the council, Mr. M. Nagaraj also. I informed him also, Lord.
Hmm.
The matter, my lord, here is, my lord, subsequent to this, my lord, the 5/8/2024. Based on this reservation, what has been, my lord, done in the, my lord, guise of, my lord, that orders of the SLP, my lord, before the Honorable Supreme Court. The state government issued this, my lord, and then, my lord, the further, my lord, calendar of events also issued.
We have heard you for admission
Yes,
and interim prayer. We have only issued notice. You
notice.
can't re-argue the same matter again for interim prayer, not possible. Comply with the office objections and they will issue notice.
Yes, please.
Week's time is granted to the appellant for compliance of the office objections raised on the process fee paid by the appellant to take out notice to respond number 5.
Much, please.
Yes.
Seal number 7, A.M. Patil, Pradeep Saukar.
Sir, this may be taken up after the vacation.
At
Since
the request of learned
Pradeep
counsel
Saukar
for
is
the
not
appellant,
well.
list this matter after winter vacation.
Intra-court appeal is not maintainable.
Huh?
Intra-court appeal is not maintainable. The other day I brought it.
But anyway, the
All
next,
right, anyway, that he is not there.
Please.
Yes.
Seal number 8,
Appellants in this case.
Yes.
This appellant before this honorable court is wife of respondent number 1, who is challenging our judgment and decree passed by the family court Vijayapura, dissolving the marriage of petitioner appellant with the respondent number 1, my lord.
No delay.
No delay.
Issue notice to the respondent. Stop. In the meanwhile, there should be an ad interim order of stay of the impugned judgment in MC number 162 of 2016 on the file of the first additional principal judge, family court, Vijayapura, till the next date of hearing.
seal number 9, preliminary matters. Ratna and Shivayogima.
And the week's time. I don't know, instruction, my lordship, party to comply or not, and we have next week in
Yena?
comply ಮಾಡಿದಾರೆ.
The request of learned counsel for the complainant, list this matter after winter vacation.
Non-compliance of office objection for first time, seal number 10, Sudarshanam.
Please, my lord, 10 and 11 are, my lord, similar set of matters, my lord. In my lord, similar set of matters, my lord, has pleased to, my lord, was pleased to, my lord, grant a stay, my lord. That is, with regard to, my lord, recovery, that is, my lord, amount, whatever the difference to be paid by the, my lord, sugar factories, it is been ordered by the, my lord, learned single judge.
ಅದರಲ್ಲೂ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ರೈಸ್ ಮಾಡಿದ್ರಲ್ಲ,
ಅದರಲ್ಲೂ ಇತ್ತು ಸ್ವಾಮಿ.
ಸೇಮ್ ಮಾಡ್ರಿ, ಯಾವ್ದು ಕೊಡಿ ಅದು.
My lord, please.
Same as writ appeal 200295 of 2024, dated 3/12/2024. ಇಲ್ಲಿ learned senior counsel ಅನ್ನೋ ಬದಲು learned counsel ಅಂತ ಹಾಕ್ಬೇಕು. Yes.
Please, much up.
11, sir.
11 also.
11, same.
Seal number 12 for orders, Sangangoda V. Piradhar.
In this case, my lords, the age of the deceased not mentioned in the judgment, my lord. As per the appeal memo, claim petition, my lords, I mentioned. That is the office objection. The age of the deceased is 32 years, my lord. Deceased age is 32 years, my lord. As per the claim petition, my lords, I mentioned 32 years.
TCS ಎಲ್ರಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಎಲ್ರಿ ಮೆನ್ಷನ್ ಮಾಡ್ತೀರಾ?
ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲ,
ಹಾ?
ಅದರಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಬಂದಿಲ್ಲ. ಇನ್ ಸಿನಾಪ್ಸಿಸ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಐ ಮೆನ್ಷನ್ 32 years ಏಜ್ ಆಫ್ ದಿ ಡಿಸೀಸ್. ಅದು ಎಲ್ಲಿಂದ ಹಾಕಿರಿ ಅಂತ, ದಟ್ ಇಸ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
ಇನ್ ಸಿನಾಪ್ಸಿಸ್
ಹೌದು.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್ ಓವರ್ ರೂಲ್ಡ್. ಎಸ್
My lords, the claim petition is dismissed, my lords. Notice may be given.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು
Respondents.
ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಇದೆಯಾ?
ಹೌದು ಇದೆ. The
India.
second New India Insurance Company.
Learned counsel. Sri Mohammed Abdul Qayyum. He is requested to take notice for respondent number 2. New India Assurance Company Limited. Issue notice to respondent number 1.
Kindly post along with
Counsel
this.
for the appellants is directed to serve a copy of the appeal memo along with annexures on learned counsel for respondent number 2.
Kindly post along with this. There is one other connected matter is there.
List this
That is-
matter along with MFA 201178 of 2022.
Yes, ma'am.
ಅಲ್ರಿ ಅದರಲ್ಲಿ ಸರ್ವ್ ಆಗಿದ್ರೆ
ಇದರಲ್ಲಿ ಇಲ್ಲ ಸರ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಆಗಿಲ್ಲ.
ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದೆ.
2022.
ಅದು 2022 ಅಲ್ಲಿ ಆಗಿದೆ.
ಹಾ
23 ಅಲ್ಲಿ ಆಗಿದೆ ಅದು. ಜನವರಿ
ಅದ್ರ
2023
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ ಅಂತ ಡಿಸ್ಮಿಸ್ ಮಾಡಾರ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಬಿಟ್ರಿ ಇದ್ರೆ
ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ, ಆಮೇಲೆ PM ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಆಗ್ತೀರಿ ಅದು.
ಅದೇ
yes.
Appeal number 13, Manantesh S. Patil.
Appeal for the respondents.
Yes.
They have given,
Unserved notice. Respond number 2.
not sir, the respondent replied the affidavit along with annexure. Okay, right.
I can find one. Copy, copy. Very good. Kindly see, my lord, in affidavit, my lord, annexure R4.
Complaints ಆಗಿದೆಯಾ?
Yes, my lord, I filed the, my lord, issued the endorsement to them, my lord, stating that, my lord, annexure R4, my lord. Affidavit dated, my lord, 31/8/2024.
ಏನ್ರಿ ಅವ್ರ ಜಾಗ ಯೂಸ್ ಮಾಡೋದಕ್ಕೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ರಿ ಅಂತಂದ್ರೆ ವಾಟ್ ಇಸ್ ದಿಸ್ ಯುವರ್
No, that is not, that the direction is to consider their request, my lord. Kindly see the order of the learned single judge. Or page number 15, para 4/5, my lord. Without expressing any opinion on the merits of the case,
yes
writ petition is disposed, directing the respondent to consider the representation of the petitioner within outer limit.
yes
Then, my lord, we consider that representation, annexure R4,
ಹಾ
second para, my lord.
yes
ಅದರಂತೆ ಸದರಿ ರಾಯಚೂರು ಬಾಚಿ 20 ರಸ್ತೆಯ DC ಬಂಗ್ಲೆಯಿಂದ ಅಕ್ಸಿಯಾಳ್ ಗ್ರಾಮದವರೆಗೆ 2016ನೇ ಸಾಲಿನಲ್ಲಿ ರಸ್ತೆ ನಿರ್ಮಾಣ ಕಾಮಗಾರಿಯನ್ನು ಕೈಗೊಳ್ಳಲಾಗಿದ್ದು, ರಾಜ್ಯ ಹೆದ್ದಾರಿ ಕಾಯ್ದೆ ಪ್ರಕಾರ ಈ ರಸ್ತೆಯು ರೋ ಅಗಲಕ್ಕೆ ಒಳಗೊಂಡಂತೆ ರಸ್ತೆಯನ್ನು ನಿರ್ಮಿಸಲು
ROW
that is, my lord,
ಏನಂಗಂದ್ರೆ
affidavit, my lord, is it?
ರಸ್ತೆಯ ROW ಅಂದ್ರೆ ಏನ್ರಿ?
One.
ಅಗಲೀಕರಣಕ್ಕೆ ಅದು ರೈಟ್ ಆಫ್ ವೇ.
Formation of the state highway.
ರೈಟ್ ಆಫ್
ಒಳಗೊಂಡಂತೆ ರಸ್ತೆ ನಿರ್ಮಿಸಲು ಉದ್ದೇಶಿಸಲಾಗಿದ್ದು, ಅದರಂತೆ ಕಾಮಗಾರಿಯನ್ನು ಕೈಗೊಳ್ಳಲಾಯಿತು. ಹಾಗೂ ಈ ರಸ್ತೆ ನಿರ್ಮಾಣದ ಸಮಯದಲ್ಲಿ ಖಾಸಗಿ ಜಾಗದವರ ಅತಿಕ್ರಮಣದ ಬಗ್ಗೆ ಆಕ್ಷೇಪಣೆ ಕೂಡ ಉದ್ಭವಿಸಿರುವುದಿಲ್ಲ. ಆ ಕಾಲಕ್ಕೆ ರಸ್ತೆಯನ್ನು ಯಥಾವತ್ತವಾಗಿ ನಿರ್ಮಾಣ ಮಾಡಿ ಪೂರ್ಣಗೊಳಿಸಲಾಗಿರುತ್ತದೆ. ಕಾಮಗಾರಿ ನಿರ್ಮಾಣ ಸಮಯದಲ್ಲಿ ರಸ್ತೆ ಹೊರತುಪಡಿಸಿ ಇತರೆ ಯಾವುದೇ ಖಾಸಗಿ ಜಾಗವನ್ನು ಅತಿಕ್ರಮಣ ಕೈಗೊಳ್ಳದೆ ರಸ್ತೆಯನ್ನು ನಿರ್ಮಿಸಲಾಗಿರುತ್ತೆ. ಆದ್ದರಿಂದ ರಾಯಚೂರು ಬಾಚಿ ರಸ್ತೆ ಹೆದ್ದಾರಿ 20 ನಿರ್ಮಾಣಕ್ಕೆ ಖಾಸಗಿ ಜಾಗವನ್ನು ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವುದಿಲ್ಲ.
ಕಾರಣ ನಷ್ಟ ಪರಿಹಾರ ನೀಡಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ ಎಂದು ಉಲ್ಲೇಖ 2 ಪತ್ರದ ಮುಖಾಂತರ
What is
Sorry.
your content?
What's my content, what's my grievance is neither they have stated, my lords, what is the measurement of the highway or road.
According to
existing.
you, how much they utilized?
Not they have stated in my lords in the representation itself, annexure C.
ಏನಂತ ಹೇಳಿದೀರಾ?
ಅಲ್ಲಿ ನಾ ಬರ್ದಿದ್ದು specific I have mentioned.
15 into 20 feet.
ಹೌದು.
Huh?
ಹೌದು.
15 into 20 feet each. In each plot. 1, 2, 3, 4 and 5. 5 plots.
ಹೌದು.
In all the 5 plots, 15 into 20 feet, they've utilized.
that is my lord, they are alleging that my lord, within the municipal limits ಅಂತ ನಿಜಲಿಂಗಪ್ಪ ಕಾಲೋನಿ.
Huh?
Para 1, serial number 1 ದಲ್ಲಿ page number 17 in the representation my lord, with reference to the above subject,
17.
ಅದೇ representation
our representation
Ah,
17 ದಲ್ಲಿ
ah,
serial number 1,
yes.
with reference to the above subject, the absolute and actual possessor of and in enjoyment of the property bearing plot number 1 to 5 measuring 15 into 20 feet each situated within the municipal limits, Nijlingappa colony, besides the DC Bangla, Raichuru.
Yes.
But our contention is, my lord, we are not to utilize the any property, any site, my lord, except which is already formed the road. That is our contention, my lord.
ರೀ ನೀವು ರಸ್ತೆ ಅಗಲೀಕರಣ ಮಾಡಿರೋದು ನಿಜ.
ಅಲ್ಲ ಅಗಲೀಕರಣ ಅಂತಲ್ಲ ಸ್ವಾಮಿ, ವಾಟ್ ಎವರ್ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ರೋಡ್ ಸ್ವಾಮಿದಲ್ಲಿ ಅದನ್ನ ನಾವು ಇಂಪ್ರೂವ್ಮೆಂಟ್ ಮಾಡಿದೀವಿ
No,
ಅಷ್ಟೇ.
not possible.
That is great, the documents are there, my lord.
Why would they have a grievance?
But there, my lord, what happened, my lord, earlier, my lord, there was a huge road was there. But by encroaching all the proper neighbor, my lord, site owners, that road came to, my lord, smaller than the earlier. Then, my lord, whatever road our is there, we utilize that one. But
Oh.
suppose there is a 40 feet, my lord, earlier. By encroaching all the, my lord, neighbor, that land, it will come to the 30 feet. Anta
Same submissions, ಎಲ್ಲಾದ್ರಲ್ಲೂ ಇದೆ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, there is a documents are there.
Encroachment, what is the action that you have taken?
But encroachment, my lord, that's why, my lord, that is a road, my lord. There is a state highway road.
Encroachment, what is the action that you have
That,
taken? You have
that
taken?
we have to, when the, my lord,
ಇಷ್ಟ
development.
ಬಂದಂಗೆ ನಾವು ನಮ್ ಪ್ರಕಾರ ಇಷ್ಟು ನಮ್ದು ಜಾಗ ಇದು ನೀವ್ ಎನ್ಕ್ರೋಚ್ ಮಾಡ್ಕೊಂಡಿದ್ರಿ ನಾವು ರೋಡ್ ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ.
ಇಲ್ಲ ನಮ್ದಲ್ಲಿ ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ, ಎಷ್ಟು ಡಾಕ್ಯುಮೆಂಟ್, ಎಷ್ಟು ರೋಡ್ ಇದೆ ಅನ್ನೋದಕ್ಕೆ ನಮ್ಮ having the documents also.
One more submission, my lords. One more submission is these sites were, my lords, given by the municipality in the year 1978 to the petitioners in view of the exchange, my lords, since they have demolished the property of these petitioners. The municipality has made, my lords, exchange deed.
Contempt
House.
ನಾವ್ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
Now at least they have to say, my lords, the measurement they did not, the endorsement did not say anything about any particulars. They say that there was an existing road, we have improved. They did not say, my lords, what was the existing road and.
Therefore you raise a challenge to this. ಅಷ್ಟೇ, ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. And you have not even made a state a party.
One submission is
only the state which has the power to issue necessary directions and notify the land with a direction to declare the compensation.
But my lords, the land was already utilized by the
party
state.
name ಮಾಡಿಲ್ಲ.
National highway.
ಅವ್ರಿಗೇನ್ರಿ powers ಇದೆ?
These authorities have utilized it.
So therefore you go to the civil court then. Why did you allow them to utilize your property
Lords,
without acquisition?
Normally what they are in normal practice, what they are doing is.
Sir, without the state, you will not succeed. We have been telling this in open court in many cases. A writ of mandamus can be issued only to an officer who is bound to consider your representation. Please tell us, what can these authorities do now?
National highway.
What can they do?
Union of India.
My
Public Works Department, ನಮ್ ಸ್ಟೇಟ್ ಅವ್ರದ್ದು ಹಾಕಿದಿರಲ್ರಿ.
ಇಲ್ಲ ಅದು ಸ್ಟೇಟ್ ದವರು then not what they are saying.
The National Highway Authority has formed the road. Then why is the learned government advocate making submission?
No, PWD was not, what they are saying is earlier it was state highway. Subsequently, it was given to the national highway for formation of national. Then PWD was handed over to them, then they developed it.
Who developed the property?
The national highway.
Who?
National Highway Authority.
ಹಂಗಾದ್ರೆ they should be the necessary party.
ಇಲ್ಲ ಅವರು ಇದ್ದಾರೆ.
ನೋಡಿ ನ್ಯಾಷನಲ್ ಹೈವೇಸ್ ಅಲ್ಲಿ 2 ವಿಂಗ್ ಇದೆ. ಸ್ಟೇಟ್ ಅವ್ರದ್ದು ಒಂದು ವಿಂಗ್ ಇದೆ, ಯೂನಿಯನ್ ಗವರ್ಮೆಂಟ್ ಅವ್ರದ್ದು ಒಂದು ವಿಂಗ್ ಇದೆ.
ನ್ಯಾಷನಲ್ ಹೈವೇ ಡಿವಿಷನ್ ಚಿತ್ರದುರ್ಗ ಅಂತ
ಇವರು ದೇ ವಿಲ್ ಓನ್ಲಿ ಟೇಕ್ ಕೇರ್ ಆಫ್ ದಿ ರೋಡ್ಸ್ ಅಷ್ಟೇ.
ಸ್ಟೇಟ್ ಡಿವಿಷನ್.
Even if it is a national highway, if it is falling within the jurisdiction of the municipal limits, the public works department will take care of the road. They have got nothing to do in the matter of expansion of the road, formation, so and so. ನೀವೆಲ್ಲ representation ಕೊಟ್ಟಿರೋದು ನಮ್ಮ ಸ್ಟೇಟ್ ವಿಂಗ್ ಅವ್ರಿಗೆ.
ಇದು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ನ್ಯಾಷನಲ್ ಹೈವೇ ಡಿವಿಷನ್ ಚಿತ್ರದುರ್ಗ ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಿ.
ನಿಮ್ಮ ಇಷ್ಟ. ಬರ್ಕೊಳ್ಳಿ.
Respond number 3 minutes. We may be given liberty to challenge that endorsement.
Learned government advocate submits that a complaints affidavit of the executive engineer, public works department, Raichur, has been filed on 31/8/2024, along with a copy of the annexure R4 is given by the engineer to the deputy commissioner.
Yes, ma'am.
ಇವ್ರಿಗೆಲ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ನಮಗ್ ಕೊಟ್ಟಿಲ್ಲ.
ಇವ್ರದೆಲ್ರಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್? It is the order
Order of
learned single judge,
which is at page number 15.
huh?
Page number 15.
12
12 in the
15,
start.
page number 15.
14 in the order.
23rd of February 2022.
ಹೌದು.
ಅದಾ?
ಹೌದು.
Copy of communication dated 16/4/2024 made by the executive engineer to the deputy commissioner, Raichur, stating that during the expansion of the National Highway -20, the road commencing from DC Bungalow to Askihal village was taken up in the year 2016, and no part of any private property was utilized for expansion of the road. Full stop. Next para. However, we find that no such endorsement has been given to the complainant herein pursuant to the communication at annexure R4. Full stop. 2 week, next para. 2 weeks time is granted to the respondents to issue such an endorsement to the complainant herein, and thereafter the complainant may proceed to raise a challenge to the endorsement that would be issued in terms of annexure R4 filed along with the complaints affidavit. Full stop. The complainant is also at liberty to take any other action in accordance with law.
Submission, my lords, that His properties were not belongs to the petitioner. It was given by the municipality. Now the municipality ought to have been, my lords, encroached on the road, even if they say that.
ಅದಕ್ಕೆ ರೀ ನಾವ್ ಹೇಳೋದು ನೀವು
There is
ಈ ತರ ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡುವಾಗ ಸುಮ್ನೆ ಕನ್ಸಿಡರ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂತ ಒಂದು ಆರ್ಡರ್ ತಗೊಂಡ್ರೆ ಏನು ಪ್ರಯೋಜನ ಆಗೋದಿಲ್ಲ. And you should know who is the competent authority, whether the competent authority can do anything to consider the representation and take action. That also you should know.
State.
Otherwise, it's a waste. A wasteful exercise, Allah. Yes.
Normally, everyone is not believed that the authorities comes under the state within the definition of
But
the.
they should have the power to consider and do something on your representation. Otherwise, what is the use?
Appropriate government which is defined under.
ಮಾಡ್ಲೇಬೇಕು. Yes. The contempt petition is accordingly disposed of.
Seal number 14, John Paul.
Lords, I appear for the respondent, my lords. I file an application, my lords, seeking clarification of the interim order granted by this honorable court on 6/6/2020.
You know?
I have filed an application, my lords, for seeking clarification regarding the interim order granted by this honorable court on 6/6/2023, my lords. Only, my lords, drawing up a final decree was stayed, my lords, and the status quo regarding entries, revenue entries was done, my lords. Now, my lords, the appellant is objecting to release of the sugarcane which was grown and harvested to the mill, my lords. Now she is opposing for release of the amount, my lords. The endorsement of the sugar mill, my lords, is produced at page number.
Clarification ಅಂತಂದ್ರೆ it has to go before the same judges. We cannot do it. We cannot clarify an order passed by some other bench, sir.
I'm also seeking direction, my lords, because only regarding the drawing up of final decree was stayed, my lords. And,
Hey, which is your application?
my lords, 1/2024, my lords.
Lord, kindly after vacation, my lord, I meet the senior, my lord.
The endorsement of the sugar mill also I have submitted along with the application notes at page number 5 of the.
Clarify the interim order ಅಂತಂದ್ರೆ it has to be placed before the same bench. ಬರ್ಕೊಳ್ಳಿ. IA number 1/2024 is filed by
The respondent, my lords, respondent number,
respondents, all represents, all respondents.
respondent number 1 to 3, my lords, and 5 to 8.
ಅದನ್ನು ಬರ್ದಿಲ್ಲ ನೀವು ಅಪ್ಲಿಕೇಶನ್.
I'll submit.
You are simply respondent.
I am permitted to,
ಬರೀರಿ ಯಾವ ರೆಸ್ಪಾನ್ಸ್ ಅಂತ ಬರೀರಿ.
please, my lords.
ಇಲ್ಲಿಗೆ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇದೆಯಲ್ಲ ಅದೇನಾ?
Yes, my lords.
1, 2 and 5 to 8. Under section 151 of CPC, seeking clarification of the interim order passed by this court on 6/6/2023. Full stop. Since the said order was not passed by this bench, comma, the application will have to be considered by the bench which passed the said order dated 6/6/2023. Yes.
Seal number 15, GG Chakshetty.
Yes. 25 ಮಾಡಿದ್ದೀರಾ? ಇಲ್ಲಿ ಬಿಡಿ 25 Yes.
That's done. They have filed the affidavit, not stating that, not sir. In the land of the survey, but petition number, page number, survey number 20, measuring 27 acres, there is no land. The houses are already constructed, therefore it's not possible. But
Petition for Podi.
yes, miss. Lordship kindly see annexure R3.
ಏನ್ ಹಾಕಿದ್ರಾ ನೀವು affidavit?
Yes, my lord, I filed the affidavit, my lord, of the ADLR and also annexure R3. my lord.
ಆಯ್ತಾ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲಿ ಪೋಡಿ ಮಾಡಕ್ಕೆ ಬರ ಯಾಕಂದ್ರೆ there is a building are there. That is not the nature of the agriculture land, my lord. Question of my lord, podi doesn't arise.
And they say that it comes under the municipality.
Page number 3.
They have not issued endorsement. Say if suppose the endorsement is issued with that effect, matter, I have challenged that person. They are not issued endorsement.
Lordship, annexes R3, page number 6.
Huh?
Annexes R3, my lord. They have stated not last paragraph. ಮಾನ್ಯರೇ, ಸದರಿ ವಿವಾದಿತ ವ್ಯಾಜ್ಯ ಸ್ವತ್ತು ಯಾದಗಿರಿ ಜಿಲ್ಲೆ ಸುರಪೂರು ತಾಲೂಕಿನ ಸುರಪೂರು ಹೋಬಳಿ ಸುರಪೂರು ನಗರ ಪ್ರದೇಶ ವ್ಯಾಪ್ತಿಯೊಳಗೆ ಇದ್ದು ಸದರಿ ಸರ್ವೆ ನಂಬರ್ ಯಾವುದೇ ಕೃಷಿ ಜಮೀನು ಇರುವುದಿಲ್ಲ ಹಾಗೂ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 13/1 2.3 ಸಂಪೂರ್ಣ ಮನೆಗಳು ಮತ್ತು ಪುರಾತನ ಬಾವಿ ಹಾಗೂ ರಸ್ತೆಗಳು ಇರುತ್ತವೆ. ರಿಟ್ ಅರ್ಜಿದಾರರು ಮೋಜಣಿ ಅರ್ಜಿ ಸಂಖ್ಯೆ ರಂತೆ ಪಹಣಿ ಹಕ್ಕಿನ ವಿಸ್ತರಣೆ ಸೋಣಿಸೋ ತಾಳೆ ಇಟ್ಟು ಪೋಡಿ ಮಾಡುವಂತೆ ಮೋಜಣಿ ತಂತ್ರಜ್ಞಾನ ಅರ್ಜಿಯಲ್ಲಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಆದರೆ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ದಲ್ಲಿ ಅರ್ಜಿದಾರರು ಅನುಭವ ಹಾಗೂ ಸ್ವಾಧೀನ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಮತ್ತು ಸದರಿ ವ್ಯಾಜ್ಯ ಸ್ವತ್ತಿನ ಸಂಪೂರ್ಣ ಮನೆಗಳು ರಸ್ತೆಗಳು ಪುರಾತನ ಬಾವಿಗಳು ಇರುವುದರಿಂದ ತಾತ್ಕಾಲಿಕ ಪೋಡಿ ಮಾಡಲು ಬರುವುದಿಲ್ಲ. ಮುಂದುವರೆದು ರಸ್ತೆ ಉಲ್ಲೇಖ 6ರಂತೆ ಸದರಿ ವ್ಯಾಜ್ಯ ಸ್ವತ್ತಿನಲ್ಲಿ ಸಂಪೂರ್ಣ ಮನೆಗಳು ಪುರಾತನ ಹಾಗೂ ಬಾವಿ ರಸ್ತೆಗಳು ಇರುವುದರಿಂದ ಹಾಗೂ ಸದರಿ ವ್ಯಾಜ್ಯ ಸ್ವತ್ತು ನಗರ ವ್ಯಾಪ್ತಿಗೆ ಒಳಗೊಂಡಿರುವುದರಿಂದ ಕಾರಣ 1964 ಕರ್ನಾಟಕ ಮುನ್ಸಿಪಲ್ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಸದರಿ ಅಳತೆ ಕಾರ್ಯ ನಮ್ಮ ಇಲಾಖೆ ವ್ಯಾಪ್ತಿಯಡಿ ಕಾರ್ಯ ಮಾಡಲು ಬರುವುದಿಲ್ಲ. ಅದಕ್ಕಾಗಿ ಮಾನ್ಯ ಗೌರವಾನ್ವಿತ ಮತ್ತು ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಒಂದು ಘನ ನ್ಯಾಯಾಲಯದ ಪೀಠ ಶ್ರೀ ಗೌರವಾನ್ವಿತ ಶ್ರೀಯುತ ಹೇಮಂತ್
ಮುನ್ಸಿಪಾಲಿಟೀಸ್ ಆಕ್ಟ್ ಕೊಡ್ರಿ. ಇದರಲ್ಲೂ ಅಷ್ಟೇ ಅವ್ರಿಗೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ನೀವು.
ಕೊಟ್ಟಿಲ್ಲ.
That's why I advised him to, my lord. The affidavit is not stated in the affidavit. Wrongly, my lord, is sent to the, but copy sent to the, my lord, complainant.
Hundred and 12D has been deleted, and you are mentioning that provision.
He will issue endorsement, my lord, to that. He will issue endorsement, my lord. On that observation, your lordship may be.
Learned government advocate submits that complaints affidavit of the Assistant Director of Land Records, Shorapur, Yadgir District has been filed along with copy of a communication dated 26/2/2024 at annexure R3 made by the ADLR to the learned government advocate. Full stop. Learned government advocate submits that it is clearly stated in the communication that survey number 13/1, 2 and 3 falls within the jurisdiction of Shorapur municipality.
Please.
ಅವ್ರಿಗೆ ಗೊತ್ತಿರೋದೆಲ್ಲ ಮನೆ ಅವರೇ ಕಟ್ಕೊಂಡಿದ್ದಾರೆ ಮನೆಗೆ. And many houses have been constructed on the lands in question, and therefore it is not within the jurisdiction of the ADLR to make a podi at this point of time. Full stop. However, we find that such an endorsement has not been issued to the complainant hearing. Full stop. Next para. Consequently, the contempt petition is disposed of while directing the concerned ADLR, respondent ADLR,
Please.
to issue an endorsement to the complainant stating the reasons as to why the OD cannot be done. Full stop. Liberty is also reserved to the complainant herein to proceed in accordance with law after having received such an endorsement at the hands of the ADLR.
That time may be fixed for issuance of endorsement. Otherwise, they are not issued the endorsement.
Fixed, 2 weeks time.
2 weeks time may be fixed for issuance of endorsement.
Copy within a period of 2 weeks from today. Yes.
Seal number 16, criminal reference case, additional SPP.
Yes.
I am in the connected appeal, my lords.
Yes.
My IA for suspension of sentence is still pending. Objection is not filed yet. My difficulty in this case is, my lords, these are women and they have small children and husbands are all working as drivers. So it has come to the point where the livelihood of the entire family has become a little difficult. They had the benefit of bail during the trial. And more importantly, the direct allegation of the crime is against accused number 1 and 2. And further, my lords, in support of my contention, there are 12 eyewitnesses. Out of 12 eyewitnesses, only 4 people who are close relative of that complainant, they have supported the case. So under such a circumstance, some stringent condition may be imposed and my IA for suspension of sentence may be considered in respect of these women, these ladies.
Reference.
Reference is for accused number 1 and 2. Accused number 1 and 2. Connected appeal is in respect of accused number 4, 5.
Or 302 ಇದೆಯಾ?
302 ಇದೆ.
ಅವ್ರದಲ್ಲಿ. ಇಲ್ಲಿ 374 only we see. CR there. Yes.
I'll file objection, my lords. Still I have not filed. It's a
ಈಗ
reference matter, my lords. New on the objection.
ಹೊಸ ಮ್ಯಾಟರ್ ಇದು.
Yes, my lords. It's a 24 matter.
24, but
and I'll have to file a reference
File.
objection, my lords, after vacation.
2 weeks are granted at the request of learned additional SPP to file objections to IA number 1 of 2020 filed at the hands of the appellant seeking suspension of sentence and bail. Yes.
Much okay.
I'm grateful, my lords.
Seal number 17. Amira Amaja Abdulkar Kunnapur.
In this matter, my lord, he given the surety, my lord, Friday. That is placing before the deputy commissioner. She was on leave, my lord. She reported the duty on Monday, my lord. Today, my lord, we are placing before the deputy commissioner. But, this is the
List it or should we dispose it of? Dispose ಮಾಡಬಹುದು.
With a direction to the deputy commissioners.
On the previous date of hearing, we had recorded the submission of the learned government advocate that the appellant is not furnishing the affidavit of the surety, which is the requirement of law, and in terms of the directions issued by the learned single judge. Full stop. Learned counsel for the complainant submitted that the complainant is ready and willing to comply with such a requirement. Full stop. Accordingly, the complainant has furnished the affidavit of the surety on 13/12/2024. Full stop. Next para. Learned government advocate therefore submits that Which is the order?
Learned single judge. Please.
Page number 1920, adena?
ಹೌದು.
Adena?
ಹೌದು.
Yaar respond number 1, na?
Yes, sir. Deputy Commissioner.
Deputy Commissioner. Huh?
Yes, please, he made the deputy director, my lord, that is wrong, your lordship is directed him to amend it, my lord. Deputy Commissioner will be considered.
That the Deputy Commissioner, Bidar, will pass necessary orders. Yavaga?
Today, my lord, we placed before the deputy commissioner, my lord. Today, my lord, it will be in 3-4 days, my lord, you are spread. Within 3 days,
On or before 20th of December.
please,
Huh?
please.
Full stop. Next para. Placing the submission of the learned government advocate on record, the contempt petition is closed.
Bill number 18, Ravi B. Patil.
Here for the
This matter, my lord.
affidavit is now, my lord, furnished to us by the accused. Kindly, my lord, it is furnished. Amount to further contempt, my lord. The previous occasion, your lordship had very clearly expressed, my lord,
2/12/2020. Order sheet dated.
before that, deputy commissioner was asked to be present. Thereafter, my lord, they filed an application that she is on leave till 13th. Then, my lord,
First order is on 11/11. Hereby, my lord, appeal preferred by the state were dismissed, and in the contempt, my lord, the deputy commissioner was directed to collect the conversion fee within 1 week and thereafter pass an order within 1 week. Then again, they came up with the, my lord, affidavit last occasion saying that, my lord, deputy commissioner is on leave for some time. Thereafter, your lordship recorded, my lord, on the last date of hearing, 12/2024. And also observed that, my lord, the order dated 11/11/24 requires to be complied by today. Again, today, my lord, they have come up with an affidavit saying that, my lord, there are 3 events, my lord, which requires to be attended by her. And, my lord, the extreme situation is, my lord, annexure R1, where it is deputing, my lord, the additional deputy commissioner, ADC, not even the deputy commissioner.
Some cooperative society election is there and she has to supervise it and therefore she has to be present. Wherever the annexure submitted by them shows, my lord, that it is ADC who has been asked to attend and not DC. And only to drag on, and further what they say is, my lord, very surprising, my lord. They again refer to judgment of the Supreme Court saying that once work, it is always a work. Therefore, once the property, after having, my lord, lost the writ appeal, they refer to a statement in the paragraph referring to the order of contempt and the also of the writ petition and the writ appeal. And they say that as per Supreme Court order in Syed Ali so-and-so has clearly had once waqf is always waqf. And then it is again matter of contempt, my lord, further contempt, my lord, where they again raise the aspect of waqf in the contempt petition.
Yes, Mr. Government.
Please, my lord. But in this matter, my lord, I am instructed to file affidavit, my lord. They only prepare it, my lord, and sent it, my lord. I have to file it. For that is the reason, my lord, I am filing this, my lord. Kindly see, my lord, here.
From 14th to 17th, she was in office. We have referred to kindly. I am making little submission. I am further making submission, sir. Please. From 14th, my lord, to 17th.
Please, my lord. In this matter, my lord, this affidavit is filed, my lord. For this reason, my lord, this is a work property and our writ appeal is dismissed. Then, my lord, we are also, my lord, requested the government to permit us to issue the necessary GO to prepare the SLP, but letter is returned to the government. That is one thing. Another thing, my lord, Waqf board itself is filed the writ appeal, my lord, that is listed before lordship, my lord. That is the serial number
29.
29, my lord. So Waqf Board is filed, my lord, that writ appeal. But that is the reason, my lord, the affidavit is filed by the Deputy Commissioner. We are not, my lord, avoiding the, my lord, because, my lord, we have to protect the, my lord, property of the state. For that is the reason, my lord, we are,
How can it be property of the state, mister?
because,
It is
my
the
lord,
property of the Waqf board.
that's why, my lord, they filed the
What
writ
is it you
appeal.
are doing?
But because, my lord, they filed the writ appeal.
Now claiming it's a property of the state.
That's why, my lord, this affidavit is filed for this reason, my lord.
To understand the difference?
Yes, no, that is true, my lord. Even Waqf Board also, my lord, given the letter, my lord, that is, my lord, kindly see Annexure R2.
That is why we are finding it very difficult to understand why the deputy commissioner is taking up all this on her shoulders.
That's true, my lord. That's true, my lord. Even that's why I also produced that one. They requested their letter
ಏನಾಗುತ್ತೆ?
to
It's
us.
an entry in the land records.
There is a entry, my lord.
Huh?
There is a entry, my lord, regarding the Waqf Board. In some property,
No.
they claiming that one they are the Waqf property.
My lord, may I
They
make a
they
submission?
filed the writ
And
appeal.
we have also considered and we have passed orders, even in cases where there is such an entry, to remove that name of the Waqf board. And you have complied with that.
Because, my lord, there is a notification, my lord, for that is a coming on our way.
Anyway,
But that is, my lord,
now see, only to some extent we can say, just please do this, please do. Otherwise, we will know what to
that is the, my lord, even, my lord,
take action.
not out of, sorry, now, my lord,
She wants to take that risk. Let her take.
Lord, may I make a submission?
What is she going to lose?
that is, my lord, even, my lord, half of the record, my lord.
ಅದೇನೆ.
I advise, my lord, but still, my lord, they prefer this
ಅದೇನೆ.
something.
ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಲಿ. Why is she is doing all this thing?
Please, my lord.
She was here yesterday.
She is not here.
She was in the office in Bidar, my lord.
Tahsildar.
She was in office
Sir,
in
sir.
Bidar.
She is the Deputy Commissioner.
In fact, when we approached yesterday to remind my lord to seek for calculation, we were told that appropriate answer will be done in the court. In affidavit submitted to me, there is no appeal also filed by any authority. And now they very surprisingly claim that they had rejected my NA. My entire case was there is no endorsement, no rejection order issued to me. In contempt 2003131, my lord. Neither in the writ appeal they have furnished any order, nor in the writ petition. Now in the contempt proceeding, they say that my
writ appeal ನೀವು ಹಾಕಿರೆ?
ಹೌದು ಸ್ವಾಮಿ.
ಇವ್ರು ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲ, ಇಲ್ಲ.
ಇವತ್ತಿದೆ.
Lord, serial number 29, my lord.
29.
Please,
Team conversion
Lord,
issue ಅಲ್ಲಿ
if my lord permits me, Lord, I put it in, my lord, 2 minutes brief. My lord,
statutory
please.
act, my lord.
statutory provision deems conversion ಅಲ್ಲಿ WAQF has no role.
Please,
And when there is an order of land tribunal, first they have to challenge the order of land tribunal.
my lord, I draw my lordship attention.
These lands have been, my lord, allotted to, my lord, the beneficiaries by virtue of the order of land tribunal. And thereafter, my lord, we are that is in the year 1975 itself.
My lord.
And portion of
yeah.
the property is already been converted by
Which is the latest RTC?
My lord, please. My lord, latest RTC, my lord, in my case, my lord, I have not produced, my lord, the thing. Allah,
That is the basis.
Allah, that is, my lord, I just,
You have to claim.
Allah, I will come to my lord's.
You have to claim, no, property belongs to WAQF and the RTC says so.
Please.
You'll have to show the
Allah,
RTC.
that's all. I will come to that point, my lord. The point is, my lord, here, 1973, my lord, I have produced 1973 notification, my lord. And thereafter, my lord, 1975, my lord, the land tribunal, my lord, the
Because the grievance of theirs is only is against the deputy.
And by virtue
Yes.
of operation of
My
law.
lord, I
it
just,
becomes,
my lord, in 2-3 minutes, my lord, I will just conclude my this thing. My lord, in 1973, my lord, notification is, my lord, there from the, my lord, Waqf board, showing these, my lord, the lands, my lord, survey numbers under, my lord, Haladkeri, coming under, my lord, Waqf tribunal, I mean, Waqf board. And thereafter, my lord, 1975, my lord, some of them, my lord, 3 people, my lord, one is Ningappa, another one is Devadas, and another one is, my lord, Sharuno. 3 people filed, my lord, occupancy rights before the, my lord, land tribunal. In 1975, my lord, without making the party, my lord, the Waqf board, and my lord, that came to be, my lord, allowed, and my lord, we came in writ petition in 2376 of 19, my lord, 76. My lord, that is, my lord, kindly see. My lord. In my lord, my compilation in additional, my lord, IA, as my lord, I have not produced the documents at the time of my lord, writ appeal taken up. Please, IA number 5, my lord, in that, kindly see, my lord, the land tribunal order, Lord R2, it is at page number 122. Typed copy. Proceedings of Lord Land Tribunal Bidar Taluka. Lord so and so, Lord, okay, kindly see, Lord, para 1, that is called parties present Ningappa, and para 2 Sharanu, and para 3 Lord M Devidas. Please. And Lord, this order, please, I come to final, Lord, para.
Next year, R3.
R3. R3 is, my lord, the writ petition filed by the, my lord, WAQF board. And after hearing, my lord, all the parties, it has been, my lord, kindly, I take my lordship attention to typed copy, my lord, at page number
Praying that in the circumstances
134.
stated here in this court may be pleased to
Remand,
order.
please. And after this remand, my lord, second, my lord, proceedings went on before the land tribunal. And thereafter, my lord, what had happened? Second, my lord, that immediate purpose, my lord, I do not have the copy. I draw my lordship attention, which has been, my lord, which was a part of, my lord, LRRP. Kindly see, my lord, R4. In that, my lord, R4, my lord, page number 139. My lord, 139. The challenge of, my lord, grievance order, my lord, I just draw. These lands reforms revision petitions are filed under section 120. Please.
Page?
My lord, 139. Please. These land reforms revision petitions are, may I please?
Yes.
Please. Filed under section 121E of Karnataka Land Reforms Act against order dated 31/1/89 passed in DAL so and so 88 on the file of the Land Reforms Appellate Authority, be either dismissing the appeal and reversing the order of the Land Tribunal, be either dated 29/2/1988 in LRM 1974-75. Kindly see, this appeal is against the, my lord, second Land Tribunal remand order. That second remand order, my lord, here, my lord, I coming to, my lord, order. My lord, last, my lord, that para itself I read.
And we don't find the WAQF board here.
Here, WAQF board is not a party, my lord. That's how, my lord. Here in this LRRP, my lord, WAQF board is not made a party.
Those earlier batch of
Please.
petition.
Yes.
Whom you filed again.
Yes, ma'am.
Those are not the parties here.
Here, my lord, yes, my lord.
Is someone else.
Is someone else. My lord.
We are not concerned with that one.
That is why, my lord.
You are taking us through, you please take through
yes.
the documents.
That's what, my lord. After remand order,
yes.
My lord, all the parties, my lord, appeared before the land tribunal. There, my lord, occupancy rights granted in favor of these 3 persons. Please. And that, my lord, kindly see the discussion coming in this, my lord. 139, my lord, order.
Again, WAQF board is not a party here.
That is what these 2 orders, my lord. I just tell, my lord, attention of, my lord, the relevant portion.
The matter was
Remanded.
To afford you an opportunity of hearing.
Yes.
And you, after you have been heard. If an order has been passed.
Yes.
You will necessarily be a party to the proceeding.
Yes, my lord. We were party.
That WAQF board is a party here.
Here, my lord, what had happened, my lord, after filing.
Or it is not in respect of the same persons against whom you had filed the writ petition earlier. This is some other batch of LRRP.
These are the LRs of the very same person, Ningappa.
Then how is it that
one of the occupant, that is grantee.
Party here.
That is how, my lord, that what they thought of is, my lord, this is a land tribunal order, my lord, reversed by the, my lord, this appellate authority. And then, my lord, it is only with regard to Ningappa's family, my lord, property which has been granted. And that is how, my lord, they have not made a party. And thereafter, my lord, what had happened? That LRRP, that is, my lord, in that itself come in, my lord, discussion regarding appellate tribunal, my lord, what has been ordered. That is, my lord, that's see, my lord. All these petitions arise from the past appellate authority, be there so and so, dated 31/1/89 setting aside order of the land tribunal, be there, dated 29/2/1988, rejecting applications filed by Ningappa. Devidas and my lord Sharnu for occupancy rights on the ground that lands in question had vested in the state of Karnataka as on so and so. In pursuance of the applications filed by petitioner learned herein land tribunal, granted occupancy rights in respect of various lands comprised in so and so survey number, Haladkeri village, by its order dated so and so. This order challenged by so and so, my lord. This is a discussion regarding earlier writ petition. Kindly come to my lord, page number, para number 9, my lord, page number 144.
But we still fail to understand how
Yes,
why
yes, my lord. I just draw. My lord.
Waqf board is not a party here.
Waqf board is not party,
Ah.
but what had happened, my lord, eagerness to, my lord, draw my lordship attention to that land reforms appellate authority, what has been reversed, my lord, the land tribunal second remand order, that attained finality. Either of the parties, my lord, have challenged that order before the writ court or before any other appellate court, my lord. That's how, my lord, after reversing that order, my lord, it has attained finality, and later on, my lord, the proceedings, my lord, miscommunication, as because my lord, Mutawalli, main person who was handling, he, my lord, passed away, and his, my lord, children were, my lord, minors, and
Come to the last paragraph number 12.
please. Lord, in the result, the revision petitions are allowed and the impugned orders passed by the appellate authorities set aside. Lord, that is what my grievance is. Without I be the, I'm being the, Lord, party to this proceeding, and without, Lord, knowing this, Lord, what has been ordered, Lord, reversing, where, Lord, land reforms appellate authority, I was a party. That order is, Lord, if, Lord, this order is made without, Lord, making party or in my absence, it is not binding on me. Even if it is,
Mr. Ravi,
so.
how is it that, see, in
My property is
in
not a
paragraph number 3, paragraph number 2, the court has taken note of the fact that Karnataka Waqf Board had filed the writ petition.
This is
The
with
matter
regard
was
to,
remanded.
this is with regard to survey number 56, 57, 59 and 85.
See the Karnataka Waqf Board in WP number 2376 of 76 on the ground that though it was a necessary party, it was not heard before passing the said order. On 38/1982, this court set aside the order of the land tribunal and remanded the matter to the tribunal.
Yes.
Aita, paragraph number 3 alli Waqf Board took up the matter, took up the stand, ella ide. How is it that without the presence of the Waqf Board, this order was passed?
ಈ ಆರ್ಡರ್ ಏನಿದೆ, this doesn't pertains to this property, my lord. ಈ ಪ್ರಾಪರ್ಟಿ ಸಂಬಂಧನೇ ಇಲ್ಲ.
ಅದರದ್ದು ನಿಮ್ದೆ ಅಂತ ಹೇಳ್ತಿದಾರೆ ಅವರು. We do not know.
ಇಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 50
names
para
are
2 ನಲ್ಲಿ, para 2 ನಲ್ಲಿ they have specifically given the survey numbers, survey number 56, 57, 59 and 85.
Correct.
Mine land is 61.
61. ನಿಮ್ದು?
ನಮ್ದು 15/1.
ಸೊ ಎರಡೂ ಇಲ್ಲ ಇಲ್ಲಿ.
ಎರಡೂ ಇಲ್ಲ, ಯಾವುದೂ ಇಲ್ಲ, ಸಂಬಂಧನೇ ಇಲ್ಲ.
ಅಲ್ಲ, I am Lord.
ನಿಮ್ದು 15/1.
15.
ನಿಮ್ದು
61.
61.
And moreover,
Yes.
in the same
Correct.
survey number, very same deputy commissioner
Lord,
has already granted.
I
the
further,
conversion.
my lord, I
That's
further
all.
draw my lordship attention. My lord.
Now
uh,
they cannot come up with
My
all
lord, I
this.
further draw my lordship attention, my lord, Waqf deed, my lord, which is in Urdu R5 and R6.
I should be going to all this.
Alla, that is how, my lord, the,
If a matter is inter se between you and some other private party, what is the use of seeing all your documents?
Yes.
They are raising a contention that it is our property.
That's how, my lord, we, what we,
ನೀವಾಗ notification ಮಾಡ್ಕೊಂಡು ನಿಮ್ ಪಾಡಿಗೆ ನೀವು ಇದ್ಬಿಟ್ರೆ
alla, litigations went on, my lord.
you
That's
want
how.
to see what happened between inter se between you two people.
Yes. My lord,
After remand,
that-
what happened?
Yes, after remand, this is how the situation, my lord.
He is pointing out it's not this survey number
Alla,
and
my
we
lord,
don't find their names here.
alla, that is the, my lord, the second order.
ನಿಮ್ಮ
My
ಹತ್ರ
lord.
ಇದೆಯೇನ್ರಿ?
One second.
What happened after the remand?
My lord,
First time
that,
we are-
my lord, I just, my lord, I in fact
ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ ನಮ್ಗೆ.
ರಿಕ್ವೆಸ್ಟ್ ಇಲ್ಲ ನಿಮ್ಗೆ ಕೊಡುವಂತ ಕೊಡ್ತೀವಿ ಅಂತ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಸರ್, ಇವಾಗ್ಲೇ ಕೊಡು.
ಅಂದ್ರೆ ಕೊಡ್ತಾರೆ.
And there is a in nation permission, not as per the.
It is a rented land. All lands vested in government. Then also they will do their.
Correct. The matter was remanded, as they read out, as he has pointed out, the Waqf Board challenged
Sure.
that order.
I am sorry,
which
my
was
lord.
legally passed by the
Just received, my lord, order of that, my lord, remand order
They are confused in some other document.
ಅದರಲ್ಲಿ survey number is mentioned, my lord.
Another
By
artist there,
oversight
but
in
that is-
LRRP not mentioned.
ಬೇರೆ ಹಾಕಿದ್ದೀರ
ಹೌದು.
ಬೇರೆ ಹಾಕಿ ನಮ್ಮ ಹತ್ರ ಆಂಧ್ರ
ಇದ್ರಲ್ಲಿ ಇದೆ
ಇದೆ.
sir. ಈ remand order, second remand order,
ಹಾ.
granting occupancy rights to all three.
ಹಾ.
Survey number, both the survey number are, sir, ಇದು.
ಏನಾಯ್ತು?
My lord, kindly, occupancy rights, my lord, they kindly see, my lord, the facts going, giving rise to the present litigation in briefs are that three persons, Ningu, so and so.
Why you want to read? What
Please.
happened ultimately? Please
Yes,
say
my
that.
lord. Yes, my lord. Ningu, my lord, is, my lord, granted with the survey number 56, 57.
That
And-
is in your presence. After the remand.
And
That
Sharan,
order has been passed in your presence.
yes, ma'am. And Sharanu, my lord, 57, 61, 85, 56, 59.
Correct.
And my lord, so and so, Devadas, my lord, again 61, 85, 80, I mean 57.
Yes.
So these are the, my lord, occupancy rights granted in favor of these three persons. And thereafter, my lord, the appeal been filed before the Land Reforms Appellate Authority. That is what happened, my lord. It has reversed this, my lord, remand order.
ಎಲ್ಲಿದೆ? Where
So,
is that?
my lord, that is also, my lord, I requested, they are pursuing in the, my lord, records room. The moment we get it, my lord, my lord, pass on to
We are
this.
not going to look into all those aspects now.
Alla, what had happened, my lord?
When your name is not reflected in the RTC. That is why the first question was, where is the RTC?
Alla,
Please show the RTC.
RTCL, my lord, because of this.
See, their names have been continued for so long. You will not be permitted to raise all these questions now.
Alla, this LRRP order came in, my lord, in
When if your
2003.
name is not found in the RTC and you kept quiet for decades together, you cannot now raise a objection before the deputy commissioner.
Alla, as
The
because,
connected
my
writ appeal,
lord,
they have produced the latest RTC.
as because, my
Writ appeal
lord, by,
ನಲ್ಲಿ dispose ಆಗಿರೋ writ appeal ನಲ್ಲಿ 200173 of 2024, which is disposed by lordship my lord on 11/11. Page number 37, my lord, the RTC.
ಕೊಡಿ.
Nowhere, ಎಲ್ಲೂ ಇಲ್ಲ ಇಲ್ಲ.
And there is also reference to, my lord, the order of AC permitting the alienation of these lands in column number
So work board ಹೆಸರು ಇಲ್ವೇ ಇಲ್ಲ ಇಲ್ಲಿ.
ಇಲ್ಲ ಇಲ್ಲ. And ಅಲ್ಲಿ AC order reference ಇದೆ ಸ್ವಾಮಿ 2004 assistant commissioner himself has given a alienation
Writ
permission.
appeal filed by the state.
ಹೌದು,
Our document.
our document.
ತೋರ್ಸ್ರಿ ಅವ್ರಿಗೆ.
my lord, these are the, my lord, RTCs, old RTCs, my lord. 1964, 65, and my lord, where, my lord, the.
ಹಳೇದ್ ನೋಡಿ ಏನ್ರಿ ಪ್ರಯೋಜನ? That is why we are saying, after you have suffered an order,
Yes.
your name was removed from the RTC. Their name was there from
ಅಲ್ಲ,
decades together.
ಅಲ್ಲ,
You didn't do anything.
ಅಲ್ಲ, ಅವ್ರದ್ದು ಹೆಸರಲ್ಲ ಸ್ವಾಮಿ. I mean, my lord, try to, my lord, convince here. The original grantees are 3%, my lord, as my lord read out here. And from them, my lord, whether these properties taken by, my lord, the petitioner here in, my lord, then, my lord, we, my lord, definitely, fell short because of not making us party, my lord, and bringing us, my lord, a notice of this any development. And, my lord, later on, we, my lord, started.
ಸರಿ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಮುತವಳ್ಳಿ ಚಿಲ್ಡ್ರನ್.
This court set aside the original order, remanded the matter back
Yes.
to the tribunal.
Yes.
Tribunal again passed an order in their favor.
Yes.
You are saying, no, in appeal, it was set aside. You are not able to produce a copy of that.
ಅಲ್ಲ, ಅದು ಕಾಪಿ ಸಿಕ್ತಿರೆ ತಾವನ್ಗೆ ತಕ್ಷಣ ಕೊಡ್ತೀವಿ ಸಮ್ ಅದು ಕೂಡ. ಅಲ್ಲ, ಓನ್ಲಿ ಮಿಸ್ ಇದು ರಿಮಾಂಡ್ ಆರ್ಡರ್ ಐ ಮೈ ಲಾರ್ಡ್ ಬ್ರಾಟ್ ಇಟ್ ಟು ದ ನೋಟಿಸ್ ಅಂಡ್ ದಟ್ ಅಪೀಲ್ ಆಲ್ಸೋ ಮೈ ಲಾರ್ಡ್ ವಿ ಆರ್ ಗೆಟಿಂಗ್
Copy of the RTC.
RTC ಮೈ ಲಾರ್ಡ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ.
ಯಾವಾಗಿಂದ ನಿಮ್ಮ ಹೆಸರು ಇಲ್ಲ RTC ಅಲ್ಲಿ, you are not able to say.
ಅಲ್ಲ, ಮೇಬಿ ಮೈ ಲಾರ್ಡ್ ಐ ಆಮ್ ನಾಟ್ ಸೇಯಿಂಗ್ ಸೊ ಮೈ ಲಾರ್ಡ್, ದಟ್ ಈಸ್ ಮೈ ಲಾರ್ಡ್
Don't raise a challenge at
revenue record.
time.
But because my lord, title cannot be disputed, my lord. At this stage, my lord, my lord, whatever Mutavalli's children, my lord, were
Why you are
minors.
saying RTC?
Yes, RTC, my lord, subsequently, my lord, it has been changed from 2003 or 4 onwards, my lord.
Saying all this.
My lord, because LRRP order came in, my lord, only in 2003.
Huh?
LRRP order.
ಎಲ್ಲಿದೆ? See, you are not published all that with your
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಈಗ ಓದಿದ್ದು
writ appeal.
ಇಟ್ ಈಸ್ ಹೌದು, ಅದು LRRP ಆರ್ಡರ್.
ಬೇರೆ ತಗೊಂಬಂದಿದ್ದೀರಾ?
ಅಲ್ಲ, ಅದು 2003 ಅಲ್ಲೇ ಆರ್ಡರ್ ಆಗಿತ್ತು.
ಯಾವ್ದೋ ಬೇರೆ ಸರ್ವೆ ನಂಬರ್ ರೀ?
ಇಲ್ಲ, ಇಟ್ ಈಸ್ ಮಿಲ್ಲರ್ ಪಾರ್ಟ್ ಆಫ್ ದಿಸ್ ಸರ್ವೆ ನಂಬರ್ ಓನ್ಲಿ. ಅದು ನಾನು ಇವಾಗ ತಮ್ಗೆ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಅಕ್ಯುಪೆನ್ಸಿ ರೈಟ್ಸ್ ಓದಿ ಹೇಳಿದ್ದು, The very same, my lord, order been challenged in appeal and then, my lord, LRR.
That is what we are saying.
Yes.
In LRRP, what is the survey numbers?
My lord, the LRRP survey number, my lord, here mentioned is, my lord, except 61.
We are concerned with 15/1 and 61.
As because, my lord,
Those are not mentioned here.
my lord, this LRRP, my lord, why I have brought before my lordship, my lord, attention. My lord, just to draw my lordship attention to these two orders, which we have to have an access and bring before my lords and show that, my lord, the land tribunal after, my lord, holding all these, my lord.
ಯಾವ್ದೋ ಬೇರೆ ತಗೊಂಬಂದು ತೋರ್ಸಿದ್ರೆ we will not be convinced.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದನ್ನೇ ತರ್ತೀವಿ. Land reforms appellate authority.
This, you'll also have to say, your name was entered in the RTC.
I will,
My
my
order
lord.
dated so and so.
Yes, my
and
lord.
it continued.
My lord, one day time may be granted. I will get these details, my lord. I will much struggle, my lord. We got all these documents. My lord, that appeal order only, my lord, we are unable to access, my lord. Anyhow, searching for.
This appeal is for the first time, the WAQF board wakes up only to help, my lord, the deputy commissioner at the instance of deputy commissioner.
My lord, it is a matter, my lord, where.
Deputy commissioner is avoiding, my lord, not
Even
even.
report cannot decide title.
That's how, my lord. That's how. My,
Otherwise,
my lord, my intention is, my lord, when there is a dispute to the title of the property, my lord, granting, my lord, occupancy, I mean, a conversion order or any, my lord, non-conversion order, my lord, itself is, my lord, per se illegal and cannot be done so. When dispute is there regarding this, see, many decades, my lord, this pendency is there. And because of minors, he is also, I have even, my lord, requested minor Mutawalli, who was in that day, my lord, these, my lord, orders passed. Now he is also coming on record, my lord, maybe, my lord, with his arrangements probably in coming days. My lord, thing is, my lord, genuine, whatever the, my lord, with the work board we are placing before my lords, and not beyond that, my lord.
You have not
The
stated.
title, whatever they were, please.
You have not stated the true facts.
Please.
In your writ appeal.
Please.
Please read the facts.
Please.
Please read the facts in the chronological order. Because you don't have documents, you have not mentioned anything about that in the writ appeal. You have not said from when your name was entered in the RTC.
Entered in the.
And if at all it was removed, when.
That aspect, my lord, we have not mentioned.
Because you don't have any information with you.
My lord, what my lord has.
Placed all necessary information.
That subsequent
development. The appeal filed by the state.
Yes, my lord.
They have furnished a copy of the RTC.
My lord, I definitely, my lord, agree with.
It does not figure at all.
Yes, my lord, my lord, eagerness is, my lord, the Mutawalli who was handling all these, my lord, litigation, he passed away in 2002, my lord. Before passing this LRRP order also, my lord. And thereafter, my lord, both the children, my lord, the minors, my lord, of the deceased Mutawalli, they, my lord, came to know only, my lord, when, my lord, these proceedings before the DC, and immediately they started collecting all these documents, my lord, on the request of, my lord, WAQF board. And, my lord, later, we, my lord, whatever come to us, and we prepared and filed it within 2 days, my lord, 3 days, my lord, I'm sorry. And thereafter, my lord, one more LRRP appeal order on the Swami namge sikre, we bring it to my lord's notice, and whatever, my lord, it is, my lord, looking into that, my lord, we, my lord, agree with whatever my lords, my lord, we deeply humble and obliged, my lord.
Very odd, my lord, deputy commissioner office has passed order of conversion in respect of same portion.
Very conversion order, one day Allah. Development also is taken. Development also is taken.
Institutions have come up.
There are a lot of houses.
What is the
conversion order agila
What is this?
Annexure E in the writ petition.
He is lord, he has sought for conversion order in that writ petition.
Annexure E in the.
Now they have filed a writ appeal against my writ petition.
Other layer.
Annexure E.
Annexure E.
Annexure. This is the order of
conversion order.
In respect of survey number 61/6, measuring 10 guntas for commercial purpose in favor of Srimati Praful Pandey, Ramesh Kumar Pandey. This is way back in the year 2020.
20.
Same survey number. His survey.
For 10 guntas, my lord, that is.
And this land is
That
already.
property, my lord, wholesome 22 acres.
ಇದು ಒಂದಿದೆ.
ಅದು ಒಂದೇನಾ?
ಅದು ಒಂದಾಗಿದೆ.
ಅದು
ಒಂದೇ?
ಇನ್ನೂ ಇದೆ ಅಂತೆ, but we could able to
In
secure
fact,
only this.
that property is of, my lord, 22 acres, my lord. 61 survey number.
ಹೌದ್ರಿ, ಈ ತರದ್ ಎಷ್ಟೋ ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ಗಳು ಆಗಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಬಂದಿದೆಯಲ್ಲ. ವಾಟ್ ಆರ್ ಯು ಡೂಯಿಂಗ್?
These people, my lord, because of that, my lord, minor children, they
You are
couldn't.
not going into the question of title now.
Yes, my lord. Yes, that's how, my lord. Just to, my lord, draw my lordship
For the
attention.
competent authority.
At this moment, my
Okay.
lord, when there is a title dispute to the, my lord, the title itself,
You have to go and raise the dispute before the competent authority.
my lord,
Yes.
kindly, my lord,
Learned government advocate. ಇದು serial number ಏನಿದು?
29, my lord.
Learned government advocate takes notice for response number 2 to
My lord, 2 to
5.
5.
Mohammad Ayaz Khan.
Ayap.
ನಿಂದ?
ಹೌದು.
Learned counsel Shri Ravi B. Patil, who is present before this court, takes notice for respond number 1, comma, the original writ petitioner.
Please.
ನಿಮ್ದು ಬೇರೆ ಅಲ್ವಾ? ನಿಮ್ದು ಬೇರೆ writ petition.
ನಂದು ಬೇರೆ ರಿಟ್ petition. ಅವ್ರ ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿಲ್ಲ ಅದು.
Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on the learned government advocate as well as learned counsel for respond number 1.
Please.
Next para. Learned counsel for respond number 1, original writ petitioner submits that this appeal has been filed at the instigation of the respondent state and the deputy commissioner, Bidar district, having suffered an order of dismissal of the writ appeal filed at the hands of the respondent state and the deputy commissioner in writ appeal number
200193 of 2024 and
dated
11/11/2024.
full stop. Thereafter, when contempt proceedings have been filed, contempt petition has been filed,
My lord,
the original writ petitioner,
my lord, may I make one submission?
after delay of nearly 256 days, this appeal has been filed. Full stop.
My lord, one kind submission. My lord, additional AG, Mr. Jabidullah wants to appear in this matter, my lord, writ appeal on behalf of, my lord, government.
See, again, you are making this mistake.
I'm sorry, sorry.
The state has already suffered an order of dismissal.
Yes,
How can the additional AG come and argue for you?
yeah, my lord, they sent a message and that's what
David Artha Madkali.
passing. Yes,
I think the learned additional advocates general also should be careful. I don't think they should come and make any submission in this appeal. You have already suffered an order of dismissal.
That's why, my lord.
You want to file an SLP, please go and file an SLP.
That's why, my lord, requested the
Please
government.
don't try to say anything in this appeal. Full stop. Moreover, it is pointed out that no documents worth consideration have been filed along with the writ appeal to show how the appellant, Karnataka State Board of WAQFs, has any title over the property in question, namely survey number 61 of
Halladkeri, Halladkeri K village.
Halladkeri bracket K village, Bidar Taluk and district.
Talaka district.
Full stop. Moreover, in the appeal filed by the state, copy of the latest RTC has also been produced, which clearly shows the name of first respondent alone and not the name of the WAQF board. Full stop. Learned counsel would further submit that in a writ proceedings, question of title cannot be gone into. Full stop. The respondent has been able to convince this court that being the lawful owner of the property in question and the record of rights standing in the name of respondent number 1, comma, the writ petition has been allowed while directing the deputy commissioner to pass orders of conversion. Full stop. At this stage, comma, any interim order should not be passed in this writ appeal, which would further protract the proceedings. Full stop. It is also submitted that along with the writ petition, the first respondent herein had produced copy of similar orders of conversion already passed by the deputy commissioner in respect of the same survey number. And after the order of conversion, constructions have been put up on the property in question. Full stop. Next para. Although learned counsel for the appellant seeks for a short accommodation to produce some other documents to convince this court that the WAQF board is the owner of the property and the RTC always stood in the name of the WAQF board, comma, we are not impressed. Full stop. Next para. Consequently, the interim prayer
IA 4 of 20.
in IA 4 of 2024 stands rejected. Yes.
Lord, there is another appeal, my lord.
ಇವಾಗ ಇದು ತಗೊಳ್ರಿ contempt.
Lord, there is another appeal.
Huh?
Another appeal, my lord, there is. My lord, it is in the scrutiny, my lord. May I give the number?
ಬರ್ಲಿ, that will also meet the same fate.
Same, please.
Yes. ತೆಗೀರಿ, ಈ ಕೆಳಗಡೆ ಇದೆ ನೋಡ್ರಿ ಕಂಟೆಂಪ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. Yes, Mr. Government Advocate,
Please,
you
my lord,
tell
in
us
this
what to
matter-
do now.
Right. In this matter, my lord, 28/11/2024, my lord, we requested the government to issue the GO, my lord.
This would again amount to another contempt.
That's why, but even I advised him, my lord, still, my lord, they instructed me to file the affidavit, my lord. I have no option, my lord, except filing the affidavit before lordship. If I not filed, my lord, then I will be the mistaken. For that is the reason I filed this one. Already informed to the deputy commissioner also, but still, my lord, is asking me to file this affidavit for the reason.
Learned Government Advocate.
May I make one submission, my lord. I'm sorry, my lord. On our behalf, my lord, I'll seek apology, my lord, for this affidavit. Because, my lord, I also advised her If this is filed, my lord, it will be very serious. Apart from that, my lord, I will request your lordship, my lord, we written letter to the government on 28/11/2024, my lord, requesting the government to issue the GO to prepare the appeal before the apex court. But that is, my lord, done by them only. My lord. Your lordship, I will take back this affidavit, my lord. Then your lordship adjourn immediately after vacation, my lord. If we not get the any stay order from the apex court, my lord, we'll comply this order. Because, my lord, sees don't know, my lord, I'm sorry to say that, my lord, our officer is, some of the officers are, my lord, they don't know the legal consequences. Because I'm making the submission before the open court, my lord. Twice, my lord, I advised, but still, my lord, sees, they only prepared it and sent to me. There is no option.
Why?
Because, my lord, something is, my lord, happened to her, my lord.
No, see,
That's why-
if the right message is not sent,
That's true, my lord, I do
how
understand.
to behave.
Last occasion also, my lord, your lordship order clearly stated that, my lord, next date of hearing, she must be present. In that period, that she went to the leave, my lord. That is, but here, my lord, I'm requesting your lordship, my lord, humbly, immediately after vacation, your lordship, I have it, my lord, without, my lord, I'm requesting to pass any order, my lord. If I not get the any stay order from the apex court, my lord, then your lordship may proceed.
My lord,
They had already approached, my lord, the
my lord-
honorable apex court. They have suffered an order on
Well,
this.
ಅದು ಬೇರೆ
On this
ವಿಷಯ.
point only.
One
Same
submission.
point
my lord.
ಮೇಲೆ apex court ನಲ್ಲಿ already.
Yesterday-
they have suffered an order.
Issuing conversion certificate, WAQF can claim their property in accordance with
That's
this.
why, my lord, I don't know, my lord, the state government.
That is what we are saying. Why the deputy commissioner is so hell bent on doing this?
That's why I.
Yesterday
I
when
can't,
we-
my lord,
Work board, let them take action in accordance with law. Why is she worried about that?
Please, my lord, I don't know, my lord. Even in writ appeal, my lord, Waqf board is also appeared before lordship also. They have also heard, my lord.
Now, similar SLP was filed only by the state.
State, my lord, another ground, my lord, on the judgment
And
of the,
you have not brought it to the notice of the work board at all?
but they are also
All
party,
the
my lord.
proceedings?
They are also party, my lord, in that.
Yavrali?
In that case, which is
SLP
prepared before the apex court. But I don't know, my lord. That's why, my lord, these cases, my lord.
Just to see that, my lord, the vacations are over and new.
Now tell us what to do
How
now.
they-
Only three days are left.
My lord, let
What
them,
can be done?
let them comply the order by tomorrow. My lord.
Because he is already.
Already twice, my lord, your lordship had directed them to comply the order and submit a report before this court. We have paid the conversion fees also. My lord, any. My lord, as an officer of the court, my lord, may make one submission. Even if there are any other claims by the work board or by the state, mere order of conversion will not deprive anybody, my lord, from claiming their right in the appropriate proceedings.
Now in 3 days, what is it that you
One
want?
certificate issue ಮಾಡಕ್ one ದಿವಸ ಸಾಕು ಸ್ವಾಮಿ. We have paid the conversion fees. We have paid the conversion fees.
Demand.
Only they have to issue the certificate.
This is a contempt court. There is no need for us to issue once again such a direction. That direction is already issued. And because it is not complied, you have come before this court.
Yes.
So we are not going to issue such an order once again.
May I request my lord, framing of a charges against my lord, for willful disobedience of the order again and again by the deputy commissioner. My lord, my difficulties, my lord, I am already
Lordship,
running
you are
an
done.
institution in the very same part of the land. ಇದೇ ಲ್ಯಾಂಡ್ ನಲ್ಲಿ ಇನ್ನೊಂದು ಎಕ್ಸ್ಟೆಂಟ್ 2 acres ನಲ್ಲಿ ನಮ್ದೇ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ನಡೀತದೆ.
Reject. Outright we'll reject it. And we'll have to list it again.
19th.
Other problem.
19th. By 19th, if it could be listed only to, my lord, or just for compliance, because only thing they have to do is, my lord, get the amount of calculation from us.
ನಮ್ದರ ಆಗಿದೆ, ಅದನ್ನು ಆಗಿದೆ.
Namdralli calculation, yesterday when we went to give the calculation and they said, we'll know, it will only happen after January. This is the confidence they had. That to a PM, my lord, when who does not allow us to meet the DC also. This is the statement they had made yesterday when we went to pay the assessment.
Then we'll issue warrant then.
Warrant in the sense, my lord.
The deputy commissioner, let her be present here day after.
Because, my lord, she is filed the affidavit stating that, my lord, she
We
is.
are not going to accept all that. Our orders were passed on 2/12.
11/11. First order is on 11/11.
Adalla. Previous order
And then 2/12.
giving this date was passed on 2/12.
Before that also, I got. Or all.
May I request your lordship, may I request your lordship, tomorrow, my lord, there is, she is attending the chief minister meeting, my lord. Day after tomorrow, your lordship have it this matter, my lord. She will present before lordship, my lord, then your lordship may proceed further, my lord.
The office is required to do.
Only, my lord, I am requesting because of the, my lord, the written letter, my lord, that is, Geo is not yet received. But only thing, my lord, today, tomorrow she is not available, my lord. Day after tomorrow, she will be present before lordship. On Thursday, my lord, your lordship.
Can also appear through, my lord, VC, my lord, facilities are there. Somehow they don't want to.
They don't want to complete exam file and affidavit. They don't want to.
No, we can clearly make out that she doesn't want to come.
Yes.
The
It is
intention is
again,
very clear.
That's
it's
why,
again
Lord,
and
I will
again,
take
my
back
lord,
this
they are doing.
update.
I think we'll have to issue.
But that's all. I will
warrant.
take back this update, my lord. Lordship simply adjourn this matter day after tomorrow at 2:30, my lord. For directive lordship present to deputy commissioner to present before lordship.
ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ಅಲ್ಲ, then you lordship issue warrant to them.
ಅವಾಗ ಟೈಮ್ ಇರಲ್ಲ ನಮ್ಗೆ.
ಇಲ್ಲ,
ಅದೇ ಪ್ರಾಬ್ಲಮ್.
ಅಲ್ಲ,
Their intention is,
ಅಲ್ಲ,
ಅಲ್ಲಿ open ಆಗಿ
19th
ಹೇಳ್ತಾ
ಗೆ
ಇದ್ದಾರೆ
I am asking only 19th, my lord, not 20th.
They have expressed to
ಅದು
us that
ಬೆಳಗ್ಗೆನೆ
they don't
ಬೇಕಿದ್ರೆ
want to
ಹಾಕ್ಬೋದು.
comply.
First hour ಗೆ ಬೇಕಿದ್ರೆ ಹಾಕ್ಬೋದು.
ಅದೇ 19th we can adjourn. But what should happen if she doesn't come?
ಅಲ್ಲ, that's why, my
And
lord,
she gives one more affidavit like this.
that's why,
ಏನ್
Lord,
ಮಾಡೋದು?
I will, I'll advise, my lord, only thing is, my lord, that is, I'll withdraw this, I'll take back this affidavit. my lord.
ತಗೊಳ್ಳಿ. ಬರ್ಕೊಳ್ಳಿ. Despite our directions issued on 2020.
eleven also, my lord, was the same, first order.
Which was preceded by another order passed on 11/11/2024. That we expect that orders of conversion will be passed by the deputy commissioner in compliance with the directions issued by the learned single judge, by the next date of hearing, and directing the deputy commissioner to be present before the court on the next date of hearing, the deputy commissioner has failed to appear. Full stop. Next para. We therefore deem it necessary to post the matter to hear before charges on 19th of December 2024. At 2:30 PM.
Please.
Now, if the deputy commissioner is not present before this court on the next date of hearing, this court will be constrained to issue warrant to secure the presence of the deputy commissioner. Full stop. Yes.
Great. Up to 20, my lord.
20, my lord, they have filed appeal, which is not disposed. on same point, my lord.
Let it come on 19th, my lord. 19th also, we'll also consider it and dismiss.
All matters.
Please,
19 and 20. sir.
20 also.
Seal number 21, Harshavardhan R. Mali Patil.
Filing the affidavit, my lord, of the DDPI.
Huh?
But I'm filing the affidavit of the DDPI, my lord. Now, my lord, the date is fixed, my lord, on 19/12/2024 for inspection the institution itself. There is so many, my lord, complaints against the institution, my lord. For that is the reason, my lord,
A renewal of the recognition.
yes, my lord, for that is the reason, my lord, Joint Director, my lord, issued that is Annexure R7, my lord. R7. This is the notice is issued to the institution and to all the fixing the date, my lord, for inspection on 19 and 20. So after this, getting the report, my lord, his request will be considered.
Learned government advocate has filed an affidavit of the in charge Deputy Director of Public Instructions, Vijayapura, along with a notice dated 5/12/2024 fixing the schedule for inspection of the school on 19th and 20th of December 2024. Full stop. Next para. Release this matter on 9th of January 2025.
Great.
Seal number 22, Bapugoda Siddhappa.
Complainant mostly awaiting the report of the news. Service awaited.
This matter of the service of notice on the respondent.
Yes, please.
Seal number 23, Sudarshan M.
For Malad, withdrawal of the appointed amount Malad. As per on 1911, they have filed the memo. Along with they have presented the check for compliance of this order, this honorable court honored. In going to the entire appeal memo, Malad, accident has been happened between the two vehicles, Malad. Deceased. So, husband of the claimant number 1, he was riding the motorcycle, Malad, on Honda Activo. Their vehicle, Malad, tanker, was dashed from the hind side, Malad. He was in fall in the back side of the wheel. Their case is that contributing negligence has to be apportionated, Malad. At any rate, Malad, in this stage, it is an earlier stage, 50% of the award amount I am entitled to get it, Malad. Our case rather apportionate ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿ as per appeal memo Malad. 50% I am entitled. So my humble prayer to this honorable court, Malad, we have lost the Malad breadwinner of the family, and that award amount they have deposited, Malad.
What do you say?
Lord, without my lord showing my consent 50% at this stage, my lord, they may be.
How much have you deposited?
My lord,
54 I have given the details in my IM, Malad.
54,16,500.
ಹೌದು ಸ್ವಾಮಿ ಹೌದು ಸ್ವಾಮಿ
ಇದರಲ್ಲಿ 50% ರಿಲೀಸ್ ಮಾಡಕ್ಕೆ
It may be.
ರಿಮೈನಿಂಗ್ ಅದಕ್ಕೆ ಎಫ್ಡಿ ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ
order on IA number 3 of 2024. This application has been filed by the respondent claimants seeking permission to withdraw the award amount deposited by the appellant before the tribunal. Stop. Learned counsel for the appellant insurance company submits that the appellant have raised a ground ಬರೀ liability na?
Liability, Swami.
Huh?
Only negligence is not a liability, my lord. It is a negligence point only.
Liability in the sense negligence.
ಅಷ್ಟೇ.
ಹೌದು.
Contributory negligence.
Contributory.
Ground regarding contributory negligence, which has been overlooked by the tribunal. And therefore, the amount should not be permitted to be released to the claimants. Full stop. Next para. However, we see that the appellant has deposited 50% of the award amount, that is rupees 54,16,512.
With accrued interest, madam. That is with the accrued interest.
Along with the accrued interest. Full stop. Therefore, comma, we do not see any reason why at least 50% of the amount already deposited by the appellant insurance company should not be released to the claimants. Stop. Next para. Accordingly, the application is partly allowed while permitting the claimants to seek release of 50% of the award amount deposited by the appellant insurance company, comma, which shall be subject to the final outcome of this appeal. Full stop. The rest of the amount which has been deposited by the appellant insurance company shall be kept in a fixed deposit so that it would earn interest and it will be beneficial to either of the parties.
Much of.
Huh? Fixed deposit under auto renewal scheme.
Much.
So, I am entitled for 50% of the, their 50% deposit. Please, ma'am, much obliged.
Hearing on CL number 24, Ashwardhan or Mali Patil.
My lord, as per the directions of this honorable court dated 11/11, my lord, today the instructions are issued by the government advocate. Your lordship directed some 5 points, my lord, making some 5 points to seek instructions with regard to the lake rejuvenation cess.
Yes, yes.
ಅದು ಇವತ್ತು ಬಂದಿದೆ ಸ್ವಾಮಿ, ನಿನ್ನೆ ಡೇಟ್ ಇವತ್ತು ಬಂದಿದೆ ಅಂತೆ, ಅದನ್ನ ಬರೆದು ಹಾಕ್ತಾರೆ, ಅದಕ್ಕೆ ಟೈಮ್ ತಗೋ ಬಸ್ ರೆಡ್ಡಿ ಅವರು. ಐ ಆಮ್ ಅಪೇರಿಂಗ್ ಫಾರ್ ಕೂಡ. The government has to file, my lord. Instructions, directions are to the government.
ಏನ್ ಮಾಡಿದಾರೆ ನೀವು?
ಇಲ್ಲ, I have received instructions, my lord. We have to file objections, my lord.
Objections.
ಅಲ್ಲ, ಈ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್
Instruction writing,
ಏನ?
instructions received, my lord. It should be in writing, my lord. We have received instruction of a parawise. He has given parawise reply to us.
See, not parawise remarks. Why see, you don't go through the order sheets, is it?
My lord, whatever contains.
Present when directions were issued by this court?
Basaredi.
Huh?
ಬಸ್ ರೆಡ್ಡಿ ಅವರು, ನಾನು ಬಸ್ ರೆಡ್ಡಿ ಇದ್ದೀನಿ.
ಮತ್ತೆ
ಲೆಟರ್ ಬರ್ದಿದೆ ಸ್ವಾಮಿ, ಲೆಟರ್ ಹೋಗಿದೆ, ಅದಕ್ಕೋಸ್ಕರ ಅವ್ರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕಳ್ಸಿದ್ದಾರೆ.
ಅಲ್ಲ,
ಇವತ್ತು ಬೆಳಿಗ್ಗೆ
ಅಂತಂದ್ರೆ then we'll proceed then. ಅಷ್ಟೇ.
Kindly pass over, my lord.
Detailed order has been passed on 11/11/2024. And it will be in the interest of the state also.
Yes,
Yes, my lord.
ಮತ್ತೆ ಇನ್ನೆಷ್ಟು ಟೈಮ್ ಕೊಡಕ್ಕಾಗುತ್ತೆ?
ಇಲ್ಲ, pass over, my lord. Pass over.
ಪಾಸ್ ಓವರ್ ಆದ್ರೆ
Basaredi will appear.
ಏನ್ ಮಾಡ್ತಾರೆ?
Night.
Is the same what you are holding, he'll also say.
Yesterday they have sent, my lord,
They
today.
don't want to understand what is going on in the mind of the court. Huh? Huh? 55. ಏನ್ರಿ ಅದು ಹೇಳಿದಾರೆ ಅದರಲ್ಲಿ? It is only parawise remarks.
Parawise.
What about the orders passed by this court?
My lord, what contention taken by appellants, they are given replies.
The, on
Illa,
11/11/2024, we have specifically stated as to what is the grievance. There are certain amendments brought.
It has mentioned in reply, my lord.
ಏನಂತ?
One.
All right, let them file. If they are not able to understand, it's difficult to make them understand. We'll pass orders. The last paragraph they have said the fee is utilized not only to revive and regenerate existing lakes, water bodies. It is to be utilized for formation of new water bodies also, which is totally unacceptable. ಅವ್ರೇನು ಬರೆಯಕ್ಕೆ ಬರೆದು ಬಿಡ್ತಾರೆ. They don't understand the consequences. Lake rejuvenation fee ಅಂದ್ರೆ ಅರ್ಥ ಏನ್ರಿ? Can it be used for formation of new lakes?
No.
Then this is the reply that they have given. There is only one lake ಅಂತ ನಾವು ಹೇಳಿದ್ರೆ ಏನ್ ರಿಜುವಿನೇಷನ್ ಅದಕ್ಕೆ ಇಷ್ಟೊಂದು ಫೀಸ್ ಯಾಕೆ ಕಲೆಕ್ಟ್ ಮಾಡಬೇಕು ಅಂತ ಕೇಳಿದ್ರೆ no, it is not only for rejuvenation, for creating new water bodies ಅಂತ ಬರೀತಾರೆ. This is enough to strike down the provision. It cannot be made applicable uniformly throughout the state where there are no lakes for rejuvenation. Such kind of heavy fees cannot be sought for. ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿದ್ರೆ ನಾವೇನ್ ಮಾಡೋದು? We'll proceed to pass orders. You have not filed statement of objections? Despite elaborate order being passed on 11/11/2024.
ಮಾಡಿದ್ರು.
Explaining the contention of the appellants that since only one lake and a pond is present within the local planning area of Kalaburagi, and it is the contention of the appellants that such heavy fee cannot be collected for rejuvenation of the lake, with uniform fee applicable throughout the state. And when this court sought for the response of the principal secretary, urban development department, it appears that the principal secretary has not looked into the matter. Stop. The undersecretary to the urban development department has forwarded a reply to the learned government advocate. And after going through the said reply, it is clear that the principal secretary has not taken into consideration the observations made by this court in the order dated 11/11/2024. Full stop. Next para. Nevertheless, we grant 2 weeks time to the respondents to file statement of objections. And thereafter, we'll proceed to hear the matter on merits. Yes.
Serial number 25, woman.
Take it for further hearing. Lordship may take it for further hearing.
Huh?
Lordship may take it for further hearing.
Serial number 25, government advocate.
Kindly pass on.
Pass over.
Serial number 26, Sandeep Vijay Kumar.
Present, my lord. File application, my lord, legal, LR's application is filed. My lord. As per this honorable court, my lord, 12/9/2023.
Today in the counter, I filed objections, my lord. There is a delay of around 647 days.
ಇಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ
Insurance company has filed a
Cross objections.
cross objection.
Yes.
is the first case claimant is. File application, my lord, and legal heirs, my lord, is the deceased son and daughter. Daughter and son, my lord.
He was in coma when the
Accident.
when the
For
claim
bringing
petition.
additional LRs.
Yes, my lord, additional LRs. Already wife is, my lord, is legally wedded wife is already on record of party, my lord, in MUC. Thereafter, my lord, is this honorable court, my lord, wide order dated 12/9/2023. File a application for LR's application, so that's why I file a legal. Wife already party ಇದ್ದಾರೆ ಸ್ವಾಮಿ. MUC ಅಲ್ಲೇ ಪಾರ್ಟಿ ಇದ್ದಾರೆ.
Injury case.
ಇಲ್ಲ ಮೊದಲು ಇಂಜುರಿ ಇತ್ತು ಆಮೇಲೆ ಡೆತ್ ಆಗಿದೆ ಸರ್. ಡೆತ್ ಕೇಸ್ ಈ ಪ್ರೆಸೆಂಟ್ ಡೆತ್ ಆಗಿದ್ದಾರೆ ಸರ್.
All the while he was being represented by his wife because he was in coma, my lord, soon after the accident. This is that case. And later, he,
Son and daughter ಇದ್ದಾರೆ. ಈಗ LR's application ಮಗ ಮತ್ತು
Then we'll allow the application.
my lord, what I have contended in the objections is that, my lord, the cause of death is not, yes, my lord, our lordship.
On the LR application.
LR's application.
Yes, yes, my lord.
Rest of the things, you have all the grounds to raise, you can raise.
Illa, that is 306 Indian section that is amended, Karnataka. No effect, ಅದೇನ್ ಬರೋದಿಲ್ಲ. ಆ maxim ಹೇಳಿದ್ರಲ್ಲ, that is not applicable.
I was just trying to make out that and whether now they can be brought on record. I think this would become a case to remand for the LR application. Yes, my lord. Formal objections may be noted.
Order on IA number 3 of 2024.
I had filed it in the counter today. May I pass on the objections?
Objections.
I had
Yes,
filed.
yes. This application is filed by the appellant. Srimati Elizabeth.
Yes.
wife of late Sri Nagaraj Deshmukh. To bring on record the children of the deceased. Full stop. Initially, the claim petition was filed by Sri Nagaraj.
Wife.
Through his wife, Srimati Elizabeth, since the injured Sri Nagaraj was in a state of coma. Full stop. However, during the pendency of the proceedings, Sri Nagaraj passed away, and this appeal was filed only at the hands of Srimati Elizabeth. Full stop. When these aspects were noticed, as directed by this court, the application has been filed to bring the two children on record. Full stop. Objections have been filed at the hands of the respondent insurance company to the application. Full stop. Next para. We are of the considered opinion that at this stage, when the legal representatives are required to be brought on record, there is no need to get into the other aspects of the matter which would touch upon the merits of the claim.
Inordinate delay ಅಷ್ಟೇ objection.
Huh?
Inordinate delay ಇದೆ ಅಂತ. From
Therefore,
21, he expired in 21 ಮೇಲೆ.
ಗೊತ್ತಾಯ್ತು.
ಆಯ್ತು. ಅಷ್ಟು contents.
The objections mainly is on the ground that there is a huge delay
Yes.
on the part of the wife of the deceased Mr. Nagaraj in filing the application.
Yes.
You cannot take it. They have to file another application to bring the LRs.
In my appeal also I had.
Otherwise, that appeal is being abated.
According to them, there is no need. According to them, there is no need because
No need ಅಂತ ಕಾಂಟಿನ್ಯೂಡ್ objection.
ಈಗ ಆಫೀಸ್ objections raise ಮಾಡಿದ್ದಾರೆ sir.
Objection ಅದೇ ಇದೆ ತೆಗೆದಿದೆ.
Office objection raise ಮಾಡಿದ್ದಾರೆ. So anyway, I thought if this is
see, in view of the allowing of this
yes,
application,
they can be brought on.
to permit you to amend
Yes. Yes, ma'am.
first right.
Yes,
according.
ma'am.
We therefore proceed to allow the application and permit the children of late Sri Nagaraj to come on record as additional appellants and claimants. Full stop. Next para. In the connected cross objections filed at the hands of the insurance company,
Yes.
Similarly, the cost title is also required to be amended.
Yes.
Full stop. Therefore, we permit the cross objector to amend the cost title showing the children of late Sri Nagaraj as also party respondents to the proceedings. Full stop. Both the learned counsels shall carry out the amendment in the cost title and furnish amended cost title within a period of 2 weeks from today.
I think children and wife also.
Coordinates.
ನೋಟಿಸ್ ಆಗಿದೆ.
Registration.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಎಲ್ಲಾರು ಸೇರಿದ್ರು. ಈಗ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾದಿಲ್ಲ ನಾವು ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ತೀವಿ to file ವಕಾಲತ್.
Yes, learned
ಈ
counsel.
ವಕಾಲತ್ತಿಗೆ
Learned counsel. Sandeep Vijay Kumar undertakes to file wakalat on behalf of the newly implicated respondent. Please.
One submission.
ಅವ್ರೇನು
ಮೈನರ್ ಇದ್ದಾರೆ.
minors
I think wife,
ಒಬ್ಬರು ಮೇಜರ್ ಆಗಿರೋ ಒಬ್ಬರು ಮೈನರ್ ಇದ್ದಾರೆ.
submission is wife should now come on record as an LR. She was representing the deceased because he was coma. I think she also needs to be come as an LR now on record.
So wife and children, bari children alla,
ವೈಫ್
wife and children anta barಬೇಕು.
Yes, ma'am.
Minors application ಹಾಕಿಲ್ಲ.
Wife.
ಇದು ವೈಫ್
To appoint as guardian.
ಅವಾಗ MVC ಟೈಮಿಗೆ ಹಾಕಿದ್ರು ಸರ್. Now she should come as an LR.
Yes.
ಇದ್ರಾಗಿದ್ರಿ ಅದ್ರಾಗ.
ಹಂಗಾರೆ delay is condoned and abatement is set aside. Yes.
Bill number 27, Kalaburagi.
This appeal was filed against the interim order. Now the main writ petition is disposed of. I seek an application for memo of withdrawal.
Learned counsel for the appellant has filed a memo stating that this appeal was filed on an interim order passed by the learned single judge. And now the writ petition itself has been disposed of on 12/12/2024. Full stop. The learned counsel would therefore submit that the prayer made in the writ appeal has become infructuous, and therefore the appeal may be dismissed as withdrawn. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ appeal stands dismissed as withdrawn.
Seal number 28, Ravi B. Patil.
They have 111 days. Respondent is served. I also served one of the council. He is not well. Requires. Santosh Belamgi, who had represented respondent number 41A, informed me that he is not well today.
Yaru?
Santosh Belamgi, who had represented respondent number 41A. I was also permitted to serve a copy. He is not well, and therefore he has requested the time. And he also said he will get the instruction from the client. And respondent number 41A is shown to be served.
We'll simply adjourn the matter.
After.
In the meanwhile, let him file wakala.
Please. Please.
List this matter after winter vacation.
Okay.
Bill number 30, Uday P. Umantikar.
I appears for the cavator claimants respondent. I filed application for release of amount 50%.
I have for appellant. The appeal filed by the insurance company, my lord, challenging contributory negligence. Here, my lord, the 50%.
31 lakhs, my lord.
Here, my lord, 50% liability fixed on appellant insurance company.
31 lakh 81.
ಅವಾಗಲೇ ಒಂದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ವಲ್ಲ 50%. Same order.
Please.
Out of the amount that you have deposited, 50%.
Please.
ಯಾವುದು? ಹೌದು.
Seal number 23.
Same order. ಅಮೌಂಟ್ ಎಷ್ಟು ಗೊತ್ತಾ? ಎಷ್ಟಪ್ಪ ಅಮೌಂಟ್?
31 lakhs 81,153.
ಒಂದೇ ಚೇಂಜ್.
Remaining amount ಅದು deposit.
ಸೇಮ್ ಅದ್ರಲ್ಲಿ ಹೆಂಗಿದ್ಯಾ ಹಂಗೆ?
Please.
Lord, in so far PF.
ಬಂದಿದೆಯಾ ಅದ್ರಲ್ಲಿ?
Lord, in so far process fee I have paid, my lord, during the course. Already paid.
Learned counsel for the appellant submits that steps have been taken for service of notice on respondent number 5.
Please, one more.
The office to verify and issue notice.
Claimants have also filed appeal, my lord. It may be connected with the. I'll
List MFA
20033, sir.
along with this
still
matter.
FR number.
Yes.
Please.
Seal number 31, Sudarshan.
Please. Lord, these are the appeals day before yesterday listed, and I requested my lord regarding Lord, delay. Next 60 days, below that 60 days, my lord, it is there. And in between, my lord, EP, my lord, notice has been issued. And my lord, we are under the threat of, my lord, recovery process. We are under the threat of recovery process, my lord. There is a, my lord, main objection is, my lord, difference court fees. And my lord, my lord, filed the application seeking dispensation at this moment. It is a government body, my lord, dispensation for some time, my lord. Subject to, my lord,
You can
payment.
seek extension of time, dispensation, brother.
I will make it, my lord.
Extension of time.
Extension and the, please, please. Two 2011, my lord, notification.
They said the difference court fees claimed by the registry will be paid well within 2 weeks.
Please,
Huh?
we pay, my lord, please.
ಇದ್ರಲ್ಲೆಲ್ಲ ಕೆಲವರಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡರ್ಸ್ ಪಾಸ್ ಮಾಡಿದೀವಿ ಆಗ್ಲೇ.
ಇಲ್ಲ ತಾವು
ಇಲ್ಲ.
ಇಲ್ಲ ಮಾಡೋರಿದ್ರೆ ಅದೇ ಇದಕ್ಕೋಸ್ಕರ ಲಾರ್ಡ್ ದಟ್ ಡೇ ಅರ್ಜೆಂಟ್.
You filed it in January 2024.
Yes, EP notices issued, my lord, and that's how EP notice has been issued. And there is a threat of attachment and, my lord, arrest warrant.
ಅಲ್ಲ ರೀ, why have you not paid court fees? 1 ವರ್ಷ ಆಯ್ತಲ್ಲ.
ಇದು during the compliance only we came to know, my lord. At the time of compliance,
ಹೌದು.
officers raised objection, my lord. So government, my lord, only.
2024.
But, my lord, when we moved this matters, my lord, last occasion, so there was a short time and now assembly session is going on, my lord, some, my lord, huge amount is not, every month, first week, my lord, they are getting the amount. And accordingly, my lord, they, my lord, rise now. And probably first week, they are, my lord, going to get it, my lord, this coming month, my lord. And immediately we, my lord, first preferably, my lord, even after 22nd also.
ಇದಾದ್ಮೇಲೆ ಇನ್ನು 50% ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಎಲ್ರಿಗೂ ಹೋಗ್ತಿರ.
That also we, my lord, simultaneously moving the matter for, my lord, taking approval before the, my lord.
What do you want? You want us to pass only orders on this IA?
IA and, my lord, stay also, my lord, we sought.
Stay ಹೆಂಗೆ?
Stay of, my lord, subject to
Of course, we will
50
give you 6 weeks time.
50%, please,
ಸಾಲಕ್ಕೆ ಸರೋಗುತ್ತೆ.
please, 50%, 6 weeks time, please.
Is more than 120 days.
60, below 60. Okay, all right. Under the application.
Order on IA number 3 of 2024. Though this application is filed seeking dispensation of payment of the deficit court fee, comma, it is stated in the accompanying application that within a period of 2 weeks, the deficit court fee will be paid.
Please.
Full stop. Next para. Accordingly, the application is disposed of extending the period for payment of deficit court fee by another period of 3 weeks.
Please.
Full stop. Next para. Issue notice to the respondents. Issue notice to respond number 1. Learned government advocate is directed to take notes for respond number 2. Learned counsel for the appellant is directed to serve a copy of the appeal memo along with annexures on the learned government advocate. Please stop. Next para. Though there is a delay of 22 days in filing the appeal,
Yes.
comma, learned counsel for the appellant submits that it is within the extended period of 60 days.
60 days, please.
And therefore, the delay is condonable. Full stop. It is further submitted that the first respondent claimant has filed execution case,
Yes.
and if interim order of stay is not passed, comma, the appellant will be put to grave difficulty. Full stop. Next para. Accordingly, there shall be an ad interim order of stay of the impugned judgment and award in LAC 18 of 2021 on the file of the first additional district judge and additional land acquisition, rehabilitation and resettlement authority, comma, Bidar, till the next date of hearing, comma, subject to the appellant depositing 50% of the award amount before the
The reference court,
reference court
Please.
within a period of 6 weeks from today.
Lord, may I seek 8 weeks?
Huh?
8 weeks. Please.
6 weeks.
Number 32, 33.
Lord, 32, 33, 34,
These are not
35, 38 and 39, last.
Same
please,
order.
Please, much.
Bill number 36, Machvagiri, Chenna Veeraya Siddhaya.
My lord, I am for the appellant, my lord. I am audible, my lord.
Yes.
My lord, the respondent has filed a divorce petition before the trial court, my lord, seeking a divorce on the ground that my cruelty and desertion, my lord. Along with my lord, he has filed a 24 application, my lord. It was allowed. And finally, my lord, it has the cross-examination of PW1. It has taken in a nil, my lord. On the ground that, my lord, 24 application was allowed for maintenance to the 10,000 rupees per month, my lord. The appellant is working a coolie, my lord. And my lord, the respondent is refused to come to the witness box, my lord. Finally, the defected judgment has been passed by the trial court, my lord. My lord, the financial difficulty of the appellant, the 19 days delay has been occurred, my lord. And my lord, the MC restitution of conjugal petition is still pending before the trial court, my lord. That's why I filed IA number 1 for stay the judgment, my lord. And IA number 3, my lord, the respondent has filed a ET, my lord, before the trial court.
Already there is a delay.
Yes, my lord, only 19 days delay is there, my lord. The financial difficulty of the appellant, the 19 days delay has been occurred, my lord.
Already 31st of January 2024 ಅಲ್ಲಿ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿಸಿ
ಹಾ.
ಇವಾಗ ಬರ್ತಾ ಇದೆಯಲ್ರಿ ಅಡ್ಮಿಷನ್ಗೆ, ಅದು ಅಡ್ಮಿಷನ್ ಬಂದಿಲ್ಲ.
ಅದು interlocutor application ಮೇಲೆ ಬಂದಿದೆ, my lord.
ಹಾ?
ಅದು the notice issue ಆದ್ಮೇಲೆ the respondent has filed the file ವಕಾಲತ್, my lord.
ನೋಟ್ ಹೌದಾ, ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಯ್ತಾ?
ಆಗಿದೆ ಸ್ವಾಮಿ.
ಅಂದ್ರೆ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವಾಗ ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. ಡಿಲೇ ಇರೋದ್ರಿಂದ ಮಾಡ್ಲಿಲ್ಲ, my
What
lord.
is the use?
ಅಲ್ಲ, ಈಗ restitution of conjugal petition is still pending before the trial court, my lord.
Already if she has married, remarried, now what will happen?
ಇಲ್ಲ, ಇನ್ನು ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ಆಗಿಲ್ಲ, ಖಂಡಿತ ಇಲ್ಲ.
ಅದೇನ್ರಿ ನಿಮಗೆ ಅರ್ಥ ಆಗೋದಿಲ್ವಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಕ್ಲಬ್ ಮಾಡಿ ಅಂತ
even if there is a delay, you should request the court direct the other party not to contract any marriage ಅಂತ.
ನಾನು ಟ್ರಯಲ್ ಕೂಡ
ನಿಮ್ಗೆ
ಅಲ್ಲ, ಡಿಲೇ ಇರೋದ್ರಿಂದ ಅವ್ರು ಅಲೋ ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಡಿಲೇ ಇದ್ರೇನಂತೆ? You are not passing an order of stay. You are directing the other party not to contract the marriage.
ಅಲ್ಲ, ನಾನು ರಿಕ್ವೆಸ್ಟ್
Otherwise the appeal will be frustrated.
ಅಲ್ಲ, ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಸ್ವಾಮಿ ಕೋರ್ಟ್ಗೆ, ಬಟ್ ದ ಕೋರ್ಟ್ ಇಸ್ ನಾಟ್ ಅಲೌಡ್ ದಟ್ ಅಪ್ಲಿಕೇಶನ್ ಆನ್ ದ ಗ್ರೌಂಡ್ ದಟ್ ಡಿಲೇ ಇಸ್ 19 days are there. Kindly allow the application. Interim order has to be granted, my lord.
ಏನೋ ಡಿಸ್ಪೆನ್ಸ್ ವಿತ್ ಸಾರಿ ಏನಿದು ಡಿಲೇನಾ? 19 days.
19 days, my lord.
Delay of 19 days in filing the appeal is condoned, comma, accepting the explanation offered by the appellant. IA number 2 of 2024 is accordingly disposed of. Yes.
Case number 4040, Subhas Mallapur.
IA number 1 may be allowed, my lord. Interim order has to be granted until further orders, my lord, because the restoration of conjugal rights petition is still pending before the trial court, my lord.
Really?
My lord, sir.
Case number 4040.
Insurance appeal by insurance company. There is a delay. I am ready to deposit entire amount. One is on the quantum, the first matter, my lords, on quantum as well as my lords liability on the ground that there was no coverage, my lords. Because it was an act policy. In the second case, my lords, fake policy.
To notice to the respondents. Stop. Next para. Although there is a delay of 51 days in filing the appeal, learned counsel for the appellant insurance company submits that the respondent claimants have filed execution case. And if the impugned judgment and award is not stayed, the appellant will be put to grave difficulty. Full stop. Accordingly, there should be an added order of stay of the impugned judgment and award in MVC 494 of 2022 on the file of the first additional senior civil judge and MACT, Kalaburagi, till the next date of hearing, subject to the appellant insurance company depositing 50% of the award amount before the tribunal, within a period of 6 weeks from today.
Case number 41, Subhas Mallapur.
Same order, huh? Yes.
Case number 42, Priti Patil Melkundi.
Only insurance company challenge only for quantum of in this matter.
Huh?
This insurance company challenge only quantum matter. Subject to 50% amount.
Same order. Same order. Learned counsel, Sri Sanjeev Patil has entered appearance for respond number 1.
Who's to know
about respond number 2?
To notice also. First time notice.
Notice respond number 2. You got a copy of the appeal memo? Yes, same order.
Lord, the amount be released, 50% amount, only on the quantum.
Yes, we have direct.
In this case,
Only challenge, only quantum. I pray the amount, my lord, to release the amount.
Huh?
Praying for the release of the amount. This only the quantum has been challenged.
Liberty is reserved to.
25% release. In this case, the not produce the salary certificate and appointment letter and.
Even 50% in kadame agbidutta.
Even medical bills also 9 lakhs, only 2 lakhs is there.
To seek release of 50% of the award amount, which is deposited by the appellant insurance company. Yes.
Much of B group matters, seal number 43, KM Garden.
My lord, last 3 days, I am searching file has been misplaced in our office. Last date of hearing, I request for filing objections.
Request of the learned government advocate, is this matter after winter vacation?
Some date may be fixed.
Huh?
Some date may be given.
After vacation, now date koda tappagutte.
Please.
Yes.
Seal number 44, Mahesh Patil.
My lord, in this case, on 25/10/2024, state level meeting has conducted, my lord. Last date of hearing, petitioner advocate has filed proceedings, my lord. It may be taken after vacation because, my lord, grievance of the petitioner is in proceedings, my lord.
In the matter of granting ಅನ್ನೋ ಒಂದು private ಅಂತ the order should be. ಇದು. ಒಂದು order ಬರುತ್ತೆ. ಪರವಾಗಿಲ್ಲ. ತಗೊಂಡಿದ್ದಾರೆ. ಮಾಡ್ಬಿಟ್ಟು ಅಪ್ಲೋಡ್ ಮಾಡಿರೋದ್ರಿಗೂ ಚೇಂಜ್ ಮಾಡಿ.
Serial number 44, I'm appealing petition.
State level committee meeting had grievance of the petitioner is in proceedings, my lord. It may be taken after vacation. Meanwhile,
Protection is given to you.
Yes, my lord, protection.
We have directed that they shall not make any appointments.
Yes.
That will continue.
Yes, yes, ma'am.
At the request of learned government advocate, list this matter after winter vacation. Let's stop. In the meanwhile, the interim directions given on 10/12/2024 that the respondents shall not precipitate the matter and shall not make any appointments till the next date of hearing, shall continue till the next date of hearing.
Yes.
Stop. Next para. In our previous order dated 10/12/2024, there is a correction of the typographical error made. Yes. Yes, sir. In previous order dated so and so, there was an error. Typographical error, and the same is hereby corrected.
Serial number 45, J. Augustine. For further hearing, J. Augustine.
This RFA is heard by your lordship
Yes,
two
yes.
times.
My lord, I am for respond number 2 and 3, my lord.
230.
ಯಾಕ್ರಿ
ಒಂದು citation ಅದು ಕೊಡ್ತೀನಿ.
ಹಾ
There is a citation.
ತರದೇ ಇರೋ ನೀವು 230 ತಂದ್ಬಿಡ್ತೀರಾ?
Time.
ಇಷ್ಟು ದಿವಸ ಟೈಮ್ ಸಿಕ್ತು ನಿಮ್ಗೆ ತರ್ಲಿಲ್ಲ, ಇವಾಗೇನೋ 230 ತಂದ್ಬಿಟ್ಟಿಲ್ಲ.
50 ಕೊಡ್ತೀನಿ. 230.
ಆಯ್ತು, ಪಾಸ್ ಓವರ್.
For further hearing, serial number 46, Ravi B.
With regard to the pay fixation under 41C with regard to the retired ex-servicemen based on the last basic pay scale, which was virtually revised by the authority, and thereafter the block education officer suo moto without any prior approval passes an order imposing 21 lakhs as the amount.
So question is whether block education officer can suo moto pass an order setting aside or finding fault in the pay fixation. That was what we had.
There is no power of review vested with the block education officer.
Correct.
And none of the provisions of KCSR provides such procedure to review their own order. It is only by the higher authority or through the finance authority they can recover.
So it is very clear.
Yes.
He has done all this only to take revenge on you.
Yes.
Yes. The government.
Page 73, my lord. Page 73.
No. He
Yes.
had raised this
Yes, my lord.
query, and therefore you are required to answer it. You please answer it.
My lord.
Whether the BDO would have done this action of taking up a pay fixation that has happened in the year
2013, man.
Suomoto
Yes.
and change it. Whether he has got that power is the question.
Now, I have also inquired this point, my lord.
Yes,
They have not taken permission from commissioner.
correct. So
They
therefore,
have Suomoto on 2020, they have inquiry.
you will set it aside.
Yes,
ಅಷ್ಟೇ. ಇನ್ನೇನು ಇಲ್ಲ ಇದರಲ್ಲಿ.
ಇಲ್ಲ ಅದೇ ಇದೆ my lord.
ಅಷ್ಟೇ ತಾನೇ?
Ashte, now my lord, my entire pension benefits are been held up because of this.
Yes. Purple. Where is the impugned order?
The passed by
Page
the
18,
honorable
huh?
KT, page number 18.
The petitioner is aggrieved. The impugned order passed by the Karnataka State Administrative Tribunal, Kalaburagi, in application number 20192 of 2022, dated 29th of July 2022, and the impugned order dated 31/1/2022, passed by the third respondent, block education officer. Full stop, next para. The petitioner, who is an ex-serviceman, was appointed as assistant teacher in primary school, with a appointment order dated 27/1/2007 in the pay scale of rupees 3300-6300. Full stop. The last pay, in terms of the pay slip during the services of the petitioner in the army,
Yes, fine. Excellent. Land army.
in the land army, was in the pay scale of rupees 3425-4700.
Annexure A3, page number 46.
And the basic pay in terms of the said pay slip was rupees 4,359, along with the class pay,
DNS pay and class pay.
dearness pay and class pay of rupees 150 per month.
And
Class 50, class pay
Class pay of
150.
rupees 150
Dear,
and dearness allowance of rupees 1,150.
It's not dearness
Per-
allowance, it's a dearness pay.
dearness pay out.
Dearness allowance ಅಂದ್ರೆ entitled ಆಗಲ್ಲ.
Stop. On a contention raised by the writ petitioner that having regard to rule
41C,
41C
clause 2.
of the Karnataka Civil Services Rules, sub-rule,
Subclause 2.
huh?
Subclause 2, Roman 2.
ಅಲ್ಲ,
Roman 5.
clause 2 na?
ಹೌದು.
Clause 2 of sub-rule 5 of rule 41C. that for the purpose of fixation of pay, the last drawn salary bar basic pay in the military service was required to be taken into account. The pay of the petitioner was refixed with a order dated 2012-2013. And it was directed that the petitioner is entitled for payment of arrears of rupees 6,54,353. Full stop. However, it is contended by the petitioner that he was only paid rupees 1,69,299. Full stop. It is contended that the third respondent, block education officer, made a false entry in the service book of the petitioner and put up a note that the petitioner has received the balance amount of rupees 4,85,054. Although no such payment was made to the petitioner. Full stop. In this regard, the petitioner gave a complaint against the third respondent to the Lokayukta. Full stop. Investigation was taken up by the Lokayukta against the third respondent here. Full stop. At this point of time, to wreak vengeance against the petitioner, the third respondent passed an order on 31/1/2022. ಎಲ್ಲಿದೆ ಅದು?
Page number 73.
Refixing the pay at rupees ಏನಂತ ಮಾಡಿದ್ರು ಮತ್ತೆ
He doesn't refix anything. He only disputes the refixation done earlier.
ಏನಂತ ಹೇಳಿದೆ? As it was prior to 31/1, order dated 31, order dated 2012-2013, and further directed that the petitioner is liable to refund rupees 19,45,49,025.
Plus the amount.
Along with ಏನಿದು 1,86,709.
That is the amount which they have given to me, my lord. Though it is 1,69,000.
ಇದು 19,49 interest.
ಇಲ್ಲ, from the period 2014 ಇಂದ 22 ವರೆಗೆ.
Excess salary paid ಅಂತ ಹೇಳಿ.
He claims this is the excess amount paid.
Which is the excess amount paid?
19 lakh, it is from.
19 lakh for.
1,86,000.
ಅದಕ್ಕೆ ಸಂಬಂಧನೇ ಬರೋದಿಲ್ಲ sir.
My lord.
I am entitled for 6,54,000. It cannot go to 19 lakhs.
Along with 1,86,709, totaling rupees 21,35,734, which is deductible from the salary of the petitioner. Full stop. When this was questioned before the tribunal, the application was partly allowed to the extent that the amount recoverable shall only be rupees 21,18,324, and liberty was also reserved to the petitioner to make a representation to the third respondent regarding grant of installments for payment of the excess salary. Full stop. Next paragraph. Learned counsel for the petitioner submits that the action of the third respondent, though apparently done with a view to take revenge against the petitioner, the tribunal has failed to notice the fact that such power for review of a pay fixed by the competent authority, does not lie with the third respondent block education officer. Full stop. Yeah, provision is
There is no such provision.
There is no such provision in the KCSR vesting power of review with the authority, that too a suo motu action without prior notice to the petitioner.
Only 215, my lord. 215 of KCSR. That only applies to pension, my lord, not my lord, pay fixation.
On the other hand, learned additional government advocate points out to Rule 215 of the KCSR and submits that provision is made in clause B of sub-rule 2 of Rule 215 for recovery of other government dues such as over issue of pay, allowances, or leave salary are admitted. And obvious dues such as house rent, life insurance premium, outstanding motor car, house building, traveling and other allowances. This, I think this chapter pertains to pension.
Pension, only, my lord,
It's not this.
pension. No other.
ಅಲ್ಲಿಂದ ಬರಬೇಕು. Next. Having heard the learned counsel for the petitioner, the learned government advocate, and on perusing the petition papers, we find that Rule 215, which was pointed out by the learned government advocate, will not apply to the facts of the present case, since this recovery is not sought to be made from the pension. Full stop. The petitioner is still in service.
Now
and
he is
therefore,
retired. Now he is retired.
The petitioner was in service as on the date of the order, that is 31/1.
Order, my lord,
22.
31/1/2022.
2022.
Yes.
And therefore rule 215 cannot be made applicable. Full stop. On the other hand, we also do not find any audit objection raised which would enable the competent authority to reconsider the pay fixation. Full stop. From the facts of the present case, we find credibility in the submissions made by the learned counsel for petitioner that the third respondent has passed the impugned order only to take revenge against the petitioner who had caused a complaint to the Lokayukta against the third respondent, for making false entry in the service books of the petitioner. Full stop. We are therefore of the considered opinion that the impugned order dated 31/1/2022 passed by the third respondent cannot be sustained. Full stop. Next para. Accordingly, we proceed to allow the writ petition and consequently set aside the impugned order dated 31/1/2022 at annexure 812 passed by the third respondent. Full stop. We also direct the third respondent to immediately deposit rupees 4,85,054 into the account of the petitioner, which was the balance payable from rupees
6,54,000.
6,54,353. Full stop. We also direct the state government and the commissioner for public instructions, Dharwad, additional commissioner,
Yes, ma'am.
Dharwad additional commissioner,
Additional.
to take action against the third respondent ಅದೇನಾಯ್ತು? What happened to that?
I did not proceed further because of, I did not proceed further.
My lord.
ಅಲ್ಲ, you have already approached the local.
Report ಕೊಟ್ಟಿದ್ದಾರೆ. My claim is correct ಅಂತ.
Huh?
My claim is correct ಅಂತ report ಇದೆ.
My lord. Yeah,
page number-
page 73, my lord.
Page number, report Manod of one Srimati Saira Banu Khan. Manod, she had given a report. Page number 68 ನಿಂದ 72 ವರೆಗೆ.
In terms of the recommendation made by the inquiry officer, in terms of the report submitted by the inquiry officer, as found at annexure.
This is annexure A11, Manod.
A11 dated
7/9/2020. Annex 2, Manod,
7/9/2020.
Annex to this communication. Page number 67. Manod.
7/9/2020.
My lord, 68, it is inquiry report, submitted by the third respondent
Ah.
to the additional commissioner, my lord.
Huh?
Enquiry report, my lord, it is not a local.
Enquiry. Enquiry report. Yes.
They have reference of higher officer, madam, 16/12/19 ಗೆ ಅವರಿಂದ
Ordered according.
Pending pensioner benefits if
Huh?
pending pensioner benefits could also be released. ಇದ್ರ ಸಲುವಾಗಿ ಇಟ್ಕೊಂಡಿದ್ವಿ.
All pending pensionary benefits, pensionary and retirement benefits of the petitioner shall also be released as expeditiously as possible.
ನಾನು ಲಾಗಿನ್ ಆಗಿದ್ದೀನಿ. ಮೈ ಫೋಟೋ ಆಲ್ಸೋ ಇಸ್ ಶೋಯಿಂಗ್ HCK ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ ಬರ್ತಾ ಇದೆ. ನೋಡಿ ಬಂದಿಲ್ಲ. ಇವಾಗ ಬಂತು ರೈಟ್. ಥ್ಯಾಂಕ್ ಯು.
Passed over matters. Serial number 4, Babu Rao Mangal.
For Pelicanurli live plots. Additional SPP.
Either.
Yes.
This application filed on behalf of appellant number 4 to 7. Totally 7 appellants are there. Appellants number 1 to 3 have been convicted and sentenced to imprisonment for life. As far as appellant number 4 to 7 are concerned, they have been sentenced to imprisonment for a period of 7 years maximum is there. Out of that, appellant number 5 to 7 are in judicial custody since from last more than 4 years, 1 month. And appellant number 4, more than 1 year, 11 months.
This application is filed by 4 persons.
Only 4. Appellant number 4 to 7, Manas. As per
6, 7. Yes.
yes, yes, Manas. Appellant number 4 is concerned. Manas, he was in custody of more than 1 year, 11 months, and he was on bail during trial. In view of the apex court granted bail to him during the pendency of the case. As far as the appellant number 5 to 7 are concerned, they are in judicial custody since from their arrest at the time of investigation. Now the period of their judicial custody was more than 4 years, 1 month. 5 to 7. Maximum sentence imposed to them is 7 years. More than half of the period they have already undergone.
No,
Now,
A4 only 1 year, 11 months.
Yes, Malsa. He was aged about more than 78 years. Considering his age, he has been granted bail by the apex court. He was on bail during trial. He is also convicted and sentenced to imprisonment for 7 years only. As far as there is no possibility of concluding the trial, hearing the merits on merits this appeal, since many cases more than 8 to 10 years are pending before this bench. As on date, more than 8 years sentence, the cases are pending. Now the in view of the apex court in one of the judgment I have produced, if the more than 50% of the sentence they have undergone, they are entitled for bail. In judgment of Atul alias Ashutosh, state of Madhya Pradesh, in which out of fixed term sentence of 5 years, the appellant accused has already undergone half of the sentence. The appeal against conviction of the year 2022 is not likely to reach before completes the entire sentence. Hence, a case is made out for grant of suspension sentence pending the appeal and grant bail. For the purpose of the appellant shall be produced before the trial court within a period of 1 week from today. The trial court shall enlarge the appellant on bail, appropriate terms and conditions till the final disposal of the appeal before the High Court. Before parting with the order, we must note here that notwithstanding several decisions of this court holding that when there is a fixed term of sentence, and especially when the appeal is not likely to be heard before completing the entire period of sentence, normally the suspension sentence and bail should be granted. We find that in several deserving cases, bail is being denied. Such cases should never be required to be brought before this court. The appeal is allowed in the aforesaid terms.
For what purpose? ಅದೆಲ್ಲ ಏನು ಇಲ್ವೇ ಇಲ್ಲ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ there is no such consideration at all. Hmm. ಅದ್ರ ಬಗ್ಗೆ ಅದ್ರ ಬಗ್ಗೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನು ಹೇಳ್ತಾ ಇಲ್ಲ. The judgment that is relying upon simply says these few words. No question of looking into the seriousness of the allegation, the proof against.
ನೀವೇನ್ appeal
ಅವೆಲ್ಲ
ಹಾಕಿಲ್ಲ?
ಏನು ಇಲ್ವೇ ಇಲ್ಲ. Nothing.
You are not preferred any cross appeal. ಅಲ್ಲ ನೀವೇನಾದ್ರೂ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಗೆ ನೀವು ಹಾಕಿಲ್ಲ. ವಿಕ್ಟಿಮ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಬರಲ್ಲ.
109 wherein they have been convicted in this case. For 7 years the imprisonment has been.
Yes.
That these 109 is to be taken into consideration principal offense, that is penal. 7 years will not be repeated. They not released for life. The question of what is this particular person service that
Allah, see, that will, all these arguments can be put forth.
that is it.
One, as asked by my learned brother,
Yes.
whether you have filed an appeal. Of course, it's an order passed recently, a judgment passed recently. You may file.
Yes.
But then,
We are between.
no, please understand. Even if you file an appeal, that will be considered along with this appeal.
Yes.
Huh? Avaga when it will be heard is the prashna. The question is, when it will be heard for final disposal and disposed of. That is why the Supreme Court is saying, not only this one, the previous one more, in one more such application, another such order was brought to our notice. I think that was a 2 or 3 pages order. Similar terms they have used,
But that is.
they have not said anything about the type of evidence that has been recorded against the accused persons. There is no chances of them succeeding in the appeal. Avella ಏನು ಬರೋದಿಲ್ಲ. These are the recent judgment, and you see now, we find that in several deserving cases, bail is being denied. ಈ ತರ ಹೇಳಿದ್ರೆ high courts are bound to follow this.
Judgment itself is only it has to be reminded.
That will be considered. Avaga, now, when we are considering such an application.
Yes.
For suspension of sentence and bail, this is the law that is holding the field now. And I said this type of orders have been passed recently in many such cases.
This aborted offenses are.
ಇನ್ನೊಂದು appeal.
Our ಕೊಟ್ಟಿದ್ದು.
If they award and the sentence has been passed. But yeah, being convicted in 109.
ಅದು ಬೇರೆ, ಅದು that is you can't even make that submission now. Even if you had filed an appeal, these are not the submissions that can be heard now. We can't even look into all those things.
As far as special book, who is concerned, my lord? Was on bail during the time of that.
ಇದು ಹಳೆ ಜಡ್ಜ್ಮೆಂಟ್ ಇದು. This is more elaborate.
Yes.
And various information were secured from all the states, and thereafter this order was passed.
Either daily application, Malaya, and
My learned friends, submission more than.
ಹೌದು, that has to be taken into consideration. That is how this order also has been passed. Alva,
objection is
same thing. Out of fixed term sentence of 5 years, the appellant accused has already undergone half of the sentence. Arena.
Period of investigation.
ಯಾವುದು?
479 of BN.
ಅಲ್ರಿ, this order, same thing. Out of fixed term sentence of 5 years, the appellant accused has already undergone half of the sentence. This is an appeal against conviction only. The appeal against conviction of the year 2022.
Submission of the minutes, we agree, madam. Honorable school has passed, but sentence itself is about judgment.
There, even if you file that appeal, what interim order can be passed now? There is no such interim order that can be passed. Alva.
The matter is to be remanded or reappreciated.
order. Order on IA. Order on application filed for suspension of sentence. Filed under Section 389 plus 1 of Code of Criminal Procedure. Is accused number 427.
Please.
Who are appellant number 427?
Yes.
The appellant number 427, who are accused in accused before the trial court, accused number 427, they have filed this application to suspend the order of sentence dated 3/5/2024, passed by the third additional district and session judge Kalaburagi in SC number 187/2022, which is impugned in this appeal. Pending disposal of the appeal, release the appellant number 427 on bail. The learned additional SPP filed his statement of objection containing that the alleged commission of offences are heinous in nature. Hence, the appellants are not entitled for bail. Further, they have narrated the facts of the case and also the evidence of all the prosecution witnesses, including material witnesses. The appellants do not deserve any sympathy by this court. And all the grounds sought for dismissal of this application. Learned counsel, appearing on behalf of the appellant, would submit that the accused number 4 is aged about 78 years and he has already undergone in judicial custody for 1 year, 11 months, and he was on bail. The other applicants have already completed half of the sentence imposed by the trial court. the appellants are ready to avoid the conditions which may be imposed by this court. That in view of the decision of the Honorable Apex Court rendered in special to appeal, bracket criminal number 1049/2024, Atul alias Ashutosh versus State of Madhya Pradesh. And another decision, special leave to appeal criminal number 529/2021, Sonadhar versus State of Chhattisgarh. As against this, the learned SPP has reiterated his arguments, reiterated the averments made in the statement of objection. Further, he submits that he has no objection to release A4 and accused number 4. Yes, he was on bail during the pendency of the case before the trial court, and sought for the dismissal of the age. And also, considering his age, he has no objection to release him on bail. Next, having heard the argument on both sides and perusal of materials placed before this court, the following points arise for our consideration. Whether the application filed under section 389 subclass 1 of Code of Criminal Procedure, filed on behalf of appellant number 4 to 7, who were accused number 4 to 7 before the trial court, it deserves to be allowed. What are our finding to the above points are as under number 1, affirmative, 2 as per final order. You have examined the materials placed before this court. The RG Nagara Police, Kalaburagi, submitted the charge sheet against the accused number 1 to 7 for the commission of offences punishable under section 143, 147, 148, 341, 302, 109, 120B and 201 read with 149 IPC. ಇಲ್ಲಿ ಇದಾಗಿತ್ತಲ್ಲ 1 to 7 are convicted for the offense 302 ಅಂತಲ್ಲ ಬರೋದಾರ ಇಲ್ಲಿ ಅದಲ್ಲ ಇಲ್ಲಿ ಬಟ್ ಅದಲ್ಲ ಇಲ್ಲಿ ಒಪಿನಿಯನ್ ಆಫ್ ದಿ ಜಡ್ಜ್ ಅನ್ನತ್ತೆ
Sentence is not given.
ಇಲ್ಲ ಇಲ್ಲಿ ಕರೆಕ್ಟ್ ಇದೆ.
ಸರಿ ಆಯ್ತು.
The trial court has convicted the accused
See, we cannot express our opinion now at this stage.
convicted accused for the commission of offence under section 143, 147, 148, 120B, 109 and 302 read with 149 IPC. And acquitted the accused number 1 to 7 for the commission of offence under section 504 and 201 of IPC. The trial court has also passed a sentence as under in the expected sentence. ಇಲ್ಲಿಂದ ಇಲ್ಲೇ as per the order on sentence passed by the trial court, the accused number 4 to 7 are sentenced to undergo simple imprisonment for 7 years and to pay a fine of rupees 2,000 each for the commission of offence under section 120B read with 149 IPC. And accused number 4 to 7 are sentenced to undergo SI for a period of 5 years to pay a fine of rupees 1,000 each for the commission of offence under section 109 IPC. And accused number 1 to 7 are sentenced to undergo SI for a period of 6 months for the offence under section 143 read with 149 IPC. The accused number 1 to 7 are sentenced to undergo SI for a period of 1 year for the offence under section 147 read with 149 IPC. ಅದೇನ್ ಬೇಡ ರಿಪೀಟ್ ಆಗದು ಇಷ್ಟೇ ಸಾಕದು. ನೆಕ್ಸ್ಟ್ ಬೇಡ. The recent decision of Honorable Apex Court as observed in Criminal Appeal 579 of 2024 that notwithstanding several decisions of this court holding that when there is a fixed term sentence and especially when the appeal is not likely to be heard before completing entire period of sentence, normally suspension of sentence and bail should be granted. In the case on hand, admittedly accused number 4 was on bail during the pendency of the trial and he has already undergone SI for a period of 1 year, 11 months in judicial custody. The other appellant have already undergone has already undergone in JC for from the date of their arrest.
4 year, 1 month.
That is 4 year, 1 month. ಅದೇ ಟೈಪ್ ಆಗ್ತಿತ್ತು. ಈಗ ಹೇಳಿದ್ನಲ್ಲ ದಿ ಆನರಬಲ್ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ has observed as under ಇದನ್ನ ಹಾಕ್ಬಿಡಿ ಇಲ್ಲಿಂದ ಇಲ್ಲೇವರೆಗೆ ಇಲ್ಲಿಂದ ಈ ಪ್ಯಾರ ಇದನ್ನ ಹಾಕ್ಬಿಡ್ರಿ ಸರಿ. Considering the facts and circumstances of this case and also keeping in the mind of the aforesaid decision of Honorable Apex Court, we are of the opinion that it is just and proper to allow this application with conditions. Accordingly, we answer point number 1 in affirmative. 2, for the aforesaid reasons and discussions, we proceed to pass the following order. The IA number 2 of 2024 filed under section 389 subclass 1 of CRPC is allowed. The appellant number 4 to 7 who are accused number 4 to 7 in before the trial court shall be released on bail on executing a self bond of rupees 1 lakh each with 1 surety for like sum. Next, the appellant number 4 to 7 shall not leave ಯಾವ ಊರು ಇವ್ರದ್ದು?
Gulbarga district.
Gulbarga shall not leave the jurisdiction of the this court without prior permission. Third, admit. ಅದ್ರದ್ದು ಇದನ್ನ ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ ಇಯರ್ ಮಾಡ್ಬೇಕು.
Sorry, when you are saying you have no objection, it's only in respect of this, that is enough. And you have raised objection at the bandide. Yes, yes. Bandide. Yes.
ಅಲ್ಲ ಬೇಡ ಅಂದ್ರೆ ಅದು ಬಿಡ್ತೀವಿ.
ಅಲ್ಲ ಅದು ಬೇಕಾದ್ರೆ ತೆಗೆದಾಕ್ ಕೊಡ್ಬೋದು. Not necessary.
ಬೇಡ
ಅದು ತೆಗೆದಾಕ್.
A4 you have no objection ಅನ್ನೋದು ಬೇಡ.
ಅದನ್ನು ತೆಗೆದಾಕ್.
ಅಷ್ಟೇ. ಅದು ಬೇಡ ಅಂದ್ರೆ ಬೇಡ ಬಿಡಿ.
ಬೇಡ ಅದನ್ನು ಬೇಡ ಅಂದ್ರೆ ಬೇಡ ಬಿಡಿ. Raised objection to all of them. All right.
Please. ನೀವು ಹೇಳಿದ್ದಷ್ಟೇ.
Yes.
ಇಲ್ಲ ಬೇಡ ಬಿಡಿ. ಇದೊಂದು ಐತ್ ಮೇಲೆ ಎರಡು ಕೇಳಿದಾರೆ ಸದ್ಯಕ್ಕೆ ಅಡ್ಮಿಟ್
ಅಡ್ಮಿಟ್ ಅಂತ ಬರೆದ್ರು ಇದ್ರಲ್ಲಿ ಇರ್ಲಿ ಅಷ್ಟೇ. ಅದ್ರಲ್ಲಿ ಮಾತ್ರ ಅಡ್ಮಿಟ್ ಅಂತ ಇವರ ಅಕ್ಯೂಸ್ ಕೇಸಸ್ ಅಲ್ಲಿ
ಥರ್ಡ್ ಅಡ್ಮಿಟ್ ಅಂತ ಇದು ಕೇಸ್ನಾಗ ಈ ಕೇಸ್ ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ ಮಾತ್ರ ಬರೀ 97 ಇದೆಯಲ್ಲ ಇದರಲ್ಲಿ TCR ಬಂದವಲ್ಲ.
Yes. Yes.
It's to prepare paper.
Office. Office to prepare paper.
ಸರಿ ಅಲ್ಲ ಇಲ್ಲಿ ಮಾಡಿಸ್ಬೇಕು ಅಲ್ಲ ಬರಿಬೇಕಾದ ಆಫೀಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಪ್ರಿಪೇರ್ ಪೇಪರ್ ಬರದೆ.
Serial number 25, passed over matters. Government advocate.
It arises out of the old act. Old act.
ನೋಟಿಸ್
ಆಗಿದೆ ಅದೆಲ್ಲ. It is come up only for this IA ಅಲ್ವಾ. We will hear this along with the main matter. ಅದರ್ಸ್ ಬೇರೆ ಅವ್ರ ಬೇರೆ ಇಲ್ಲ. 475 days is not a short delay.
ಇನ್ನು ಕಾಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ದುಡ್ಡು ಅಮೌಂಟ್ ಅಲ್ಲ ದುಡ್ಡು ಕಟ್ಟಿದ್ರಿ 25%.
ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಇಶ್ಯೂ
ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್
ಅದರಲ್ಲಿ 475 days ಡಿಲೇ ಇರೋದು. ಫೈಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಬ್ರಿಂಗಿಂಗ್ ದಿ LRs ಆನ್ ರೆಕಾರ್ಡ್ ಅದರಲ್ಲ ಇಶ್ಯೂ ನೋಟಿಸ್ ಆನ್ IA number 1 to 3 up to 20. ಯಾರಿಗೆ? ಫಾರ್ ಪ್ರಪೋಸ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
ರತ್ನ ಶಿವಯೋಗಿ
ಹೌದಾ? ಫಾರ್ ದಿ ಪ್ರಪೋಸ್ಡ್ ರೆಸ್ಪಾಂಡ್ ಅಂತ ಇದೆಯಲ್ರಿ
ನೋಡ್ರಿ ವಕಾಲತ್ ಹಾಕಿರಣ ಎಲ್ಲಾರು
ಅದೇನಾ?
ಪ್ರಪೋಸ್ ಎಲ್ಲಾರು ಸಾವಿರ
ತೆಗೆದ್ಬಿಟ್ಟಿದೆ. Learned counsel Srimati Ratna and Shivayogi Mat has entered appearance for the proposed respondents. Full stop. However, when the matter is called out, there is no representation for the respondents. Stop. Therefore, list these matters after winter vacation.
Please. Seal number 45 for further hearing. J. Augustine.
That this citation is actually not aptly applying to my case, my lord. That during the period of COVID, my lord, the courts have exempted. Only some 30 days delay is in this case, my lord, in the case at hand. So I pray that a lenient view may be taken.
Sir, again, we are telling you, this is not a case where for the first time you are appearing before the court and asking for time for continuation of delay and permit you to file return statement. That is not the situation here. Please don't read any judgment which does not pertain to similar situation. No consequence, no use. Authors ಏನಾರಿದೆ ದಯವಿಟ್ಟು ಓದಿ. Despite opportunity being given to you, you are not filed written statement. Therefore, can this court once again permit you to file written statement is the question. ಆತರದ್ದು ಏನಾದ್ರು ಇದ್ರೆ ದಯವಿಟ್ಟು ಓದಿ, ಇಲ್ದಿದ್ರೆ you leave it ಅಷ್ಟೇ. ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅವ್ರ ಡಿಫೆನ್ಸ್ ಏನಿಲ್ಲ. ನಿಮ್ ಡಿಫೆನ್ಸ್ ಏನಿದೆ? ಏನ್? ನೋ ಡಿಫೆನ್ಸ್.
ಡಿಫೆನ್ಸ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ, ಆದ್ರೆ ನಾನು ಇದರಲ್ಲಿ ಬರ್ದೀನಿ. ಬಿಕಾಸ್ ಮೈ ಲಾರ್ಡ್,
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಏನಿಲ್ಲ. ಮೆರಿಟ್ಸ್ ಮೇಲೆ
ಇದೆ ಮೈ ಲಾರ್ಡ್. Kindly peruse page 8, my lord. I have given my family pedigree. I have produced additional documents in this case. Khasra, my lord. In Khasra, my adopted father's name is there, my lord, in the Khasra. I have to produce all those in the trial court.
What the learned counsel for the other side was saying. It is an admitted fact that one property has fallen to your share also.
My lord, all hear and say things, my lord, it is to be, what he says is not, my lord, maybe fact or not, it is to be tried, it is to be tried and found out before the trial court.
Let us not go into the merits of the matter. Only on this ground, we will dismiss.
Please.
ಈ ಅಪೀಲ್ ನಾವು ಡಿಸ್ಮಿಸ್ ಆಯ್ತಾ? ಡಿಲೇ ಕಂಟೋನ ಇದೆ.
In time ಇದೆ.
In time.
The appellant who was defendant number 3 before the trial court has preferred this appeal against the judgment and decree passed by the senior civil judge and JMFC Devdurga in OS number 64/2019 dated 5/3/2020. Parties are referred to same rank. The brief facts leading to this appeal is that the plaintiff Somanatha has filed a suit for declaration and possession in respect of suit scheduled properties.
One prop,
ಒಂದೇ ಇರೋದು
ಹೌದು.
suit scheduled property. On the ground that the suit scheduled property survey number 7/1/2 Issa dash capital A measuring 6 acre 14 guntas and survey number 43 Issa dash capital AA measuring 15 acres 26 guntas of Nagolli village were Inam lands. And after a certain Inam Abolition Act came into force, the plaintiff's father applied for regrant of the said lands before the land tribunal Devdurga. During the pendency of the said application, the father of the plaintiff died in the year 1983. After conducting an inquiry and found the actual possession and enjoyment of the plaintiff over the said lands, the tribunal has passed an order wide number LRM/INA/83-84 dated 14/8/1984 and ordered as occupant of the said land as per section 5 subclass 3 of the Inam Abolition Act in the name of the plaintiff as registered occupants. The plaintiff got mutated the said land in his name based on the said order of the land tribunal. Accordingly, the revenue records of the said lands are also standing in the name of the plaintiff till the year 2015. The plaintiff was in actual possession and enjoyment of the suit land. However, to meet his livelihood, the plaintiff went to Bangalore along with his family. In the meanwhile, the defendant number 1 illegally encroached the suit land to the extent of 1 acre 12 guntas, and defendant number 2 encroached the suit land to the extent of 30 guntas, and defendant number 3 encroached the land to the extent of 4 acre 6 guntas. Defendants taking undue advantage of absence of the plaintiff in the village illegally got their names entered in the RFR. The defendants have no right, title or interest over the suit land. The defendant number 1 and 2 are the owners to the extent of 3 acres 7 guntas only. And when the plaintiff came to know about this fact, in the year 2015, he found the defendants illegal possession over the suit land. As such, requested them to deliver the possession of the suit property. But defendant number 1 and 2 disputed the measurement of the suit land. As such, plaintiff applied for Tatkal-4D survey under application number 060-2021-920-4490. The survey authority conducted the survey and found that defendant number 1 has encroached to the extent of 1 acre 12 guntas, and defendant number 2 has encroached the suit land to the extent of 30 guntas, and defendant number 3 is in possession of 4 acre 6 guntas of the suit land. Even after conducting survey, the defendants are not ready to hand over the vacant possession of the suit property to the plaintiff. Lastly, on 10/6/2019, plaintiff again requested the defendants to deliver the vacant possession of the suit land, but the defendants denied his title and refused to deliver the possession. On all these grounds, sought for decree the suit. Next, after due service of suit summons, the defendant number 3 entered appearance through his advocate. Defendant number in spite of due service of summons, the other defendants. ಇವ್ರು ಒನ್ ಅಂಟು ಇಬ್ರು ಎಕ್ಸ್ಪರ್ಟ್ ಅಲ್ಲ?
ಇಲ್ಲ ಅವ್ರಿಗೂ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ.
ಇಲ್ಲಿ ಎಕ್ಸ್ಪರ್ಟ್ ಡ್ಯೂ ಸರ್ವಿಸ್ ರಿಮೈಂಡ್ ಆಬ್ಸೆಂಟ್ ಅಂತ.
ಇಲ್ಲ ಬಟ್ ದೇ ಆರ್ ರೆಪ್ರೆಸೆಂಟೆಡ್ ನೋಟ್ಸ್ UMM ಅಡ್ವೊಕೇಟ್ ಅಂತ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬಂದಿದೆ.
ಬೈ VVM ಅಡ್ವೊಕೇಟ್. ಬಟ್ ಇಲ್ಲಿ
PMM
ಇದರಲ್ಲಿ ಯಾರ 3
ಇಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಅಲ್ಲಿ ಇದೆ.
ಇಲ್ಲಿದೆ
ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಅಲ್ಲಿ ಇದೆ.
ಅವರು ಅಪೇರ್ ಆಗಿದ್ದಾರೆ.
ಥ್ರೂ ಅಡ್ವೊಕೇಟ್ ದೇ ಆಫ್
1 to 3.
ಹೌದು 1 and 2 are represented by notes VMM advocate. Defendant number 3 is represented by BS advocate. The defendant number 3 is in appeal.
Also appeared through his counsel, through their counsel. ಇಲ್ಲಿ ಪ್ಲೇಸ್ ಎಕ್ಸ್ಪರ್ಟ್ ಅಂತ ಬರೆದಾರೆ.
ಬಟ್ ಇಲ್ಲಿದೆ ಇದರಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಅಲ್ಲಿ.
ಇಲ್ಲಿದೆ came to be allowed.
ಇಲ್ಲಿ ಕೆಳಗಡೆನೂ ಬಂದಿದೆ ಆಮೇಲೆ ಹಾಕಿದ್ದಾರೆ. ಪ್ಯಾರಾ ಪೇಜ್ ನಂಬರ್ 8 of the judgment notes.
Despite sufficient opportunity was provided to the defendants, defendant number 1 to 3 have not filed the written statement. Next paragraph. To prove the case of the plaintiff, the plaintiff Somnatha himself examined as PW1. 18 documents, 21 documents were marked as exhibit P1 to 21. On closure of plaintiff side evidence, defendants have not adduced any evidence on their behalf. Having heard the arguments, having the trial court has decreed the suit with costs. They have sought for being aggrieved by this judgment and decree passed by the trial court. ಇವರು ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ಮಾತ್ರ ಅಪೀಲ್ ಹಾಕಿರೋದಿದೆ.
ಇಲ್ಲ 3.
ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 3 ನಾಗವೀರಯ್ಯ.
ಹೌದು ಡಿಫೆಂಡ್ ನಂಬರ್ 3.
Yes, preferred to appeal.
I am defendant number 1 and 2 ಮೇಲೆ before trial court ಮೇಲೆ.
ಹಾಕಿಲ್ಲ ಅದರ ಹಾಕಿ.
ಯಾರು?
ಅಲ್ಲ ಅವರು ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1, 2 ಗೆ ಇಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Present respondent number 2 and 3 are the defendant number 1 and 2.
ಅಲ್ಲ ಒಬ್ಬರೇ ಈಗ ಅಪೀಲ್ ಹಾಕಿರೋದು.
ಹೌದು ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 3 is in appeal.
1 and 2 are not preferred appeal.
Not preferred appeal.
Yes, we have not challenged that judgment, my lord. But I am supporting appellant.
ಇಲ್ಲ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಅವರು.
Through counsel appeared ಆಗಿದ್ದಾರೆ. 2 and they are respondent number 2 and 3.
The learned counsel appearing on behalf of the appellant would submit that the judgment and decree, the impugning judgment and decree passed by the trial court is outcome of incomplete facts due to non-filing of written statement by the appellant. The plaintiffs have not approached the court with clean hands. Plaintiff have suppressed the material facts. Then sought for allow this appeal by providing an opportunity to the defendant, to the appellant to file his written statement and proceed with the case. Next for next this the another advocate who has appeared on behalf of the respondent number 2 and 3 would support the
case of
the appellant. and sought for allow this appeal. Next, the learned counsel for the respondent will submit that. ಇದ್ರಾಗ ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ?
ಇಲ್ಲ, ಅವತ್ತು ಕೊಟ್ಟಿದ್ದೆ ಬಟ್
ಅದು ಕೊಟ್ರೆ ಇಲ್ಲಿ ಇದೊಂದು to substantiate his argument, the learned counsel of the appellant has relied on the decision of the Honorable Apex Court 2022 SC online SC 1315 Baba Saheb ಇದೆ ನೋಡಿ ಆರ್ಡರ್ ಶೀಟ್
ಇಲ್ಲಿ 22/10/2019
that
IA number 3 filed by the defendant number 3 appellant herein, my lords, was allowed.
trial court has appreciated the evidence on record in accordance with law and facts. Absolutely defendants have no right, interest, title whatsoever over the suit schedule property.
Order sheet dated 22/10/2019. ಅಲ್ಲೇ ಸ್ಲಿಪ್ ಹಾಕಿ ಅಲ್ಲಿ ಕೆಳಗೆ ಲಾಸ್ಟ್ ಬಾಟಮ್.
The trial court has provided sufficient opportunity to the accused, to the defendants to file their written statement. However, the defendants have not filed their written statement. Hence, this trial court has passed an order. ಇದು ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಆಗಿರೋದು ಇದು.
ಇದ ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ ಆಗಿದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಅವ್ರು IA number 3 ಹಾಕಿದ್ರು. ಅದನ್ನ ವಿ ಸೆಡ್ ನಾಟ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಟು ಅಲೋ ದಿ IA number 3 22/10/2019. ಈ ಕಡೆ 22/10/2019 ಆರ್ಡರ್ ಶೀಟ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇರುತ್ತೆ.
ಇಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಟೇಕನ್ as ನಿಲ್ಲ ಅಂತ ಆಯ್ತು
ಇಲ್ಲಿ
7-9 ಗೆ.
ಇಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಅದು 22/10/2000 ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಇರ್ಬೇಕು ಸ್ವಾಮಿ. ಈ ಕಡೆ ಅಲ್ಲಿ ಕೆಳಗಡೆ ಲಾಸ್ಟ್ 22/10/2019 ಅದ್ರ ಕೆಳಗಡೆ
ಇಲ್ಲಿ
ಹಾ ಅಲ್ಲಿ IA number 3 ಅಲ್ಲ ಅವ್ರು ಹಾಕಿದ್ರು. ಅದು ವಿ ಸೆಡ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ಸ್, ಇಟ್ ಈಸ್ ಅಲೌಡ್ 100 rupees with 100 rupees ಕಾಸ್ಟ್.
That on 7/9/2019, the defendant number 3 they had filed an application under Order 8 Rule 1 read with Section 148 of CPC. Same was allowed by the trial court. And the case was posted to 22/10/2019. On that day, also defendant number 3 filed application under Order 8 Rule 1 read with 148 IP CPC. Same was allowed by the trial court with cost of ₹100. And time was granted to the defendant number 3 to file his written statement on 22/11/2019. That on 22/11/2019, the advocate for defendants present, but they have not filed any written statement. Hence, the case was posted for evidence.
ಅದಾದ್ಮೇಲೆ ಅಷ್ಟೇ.
Accordingly, the trial court has recorded the evidence of PW1. This conduct of defendant number 3 reveals that though the trial court has provided sufficient time to file his written statement, the defendant number 3 has not filed his written statement. Even after recording the evidence of PW1 also, The defendant number 3 has not, defendants have not filed the written statement and contest this case. Only to protract the proceedings, the appellants have filed this appeal
Para 14 and 16.
and sought for remand the case to the trial court, which is not sustainable under law, and all these grounds sought for dismissal of this appeal. To substantiate his argument, he relied on the decision of the Honorable Apex Court rendered in the civil appeal number 4266-4267 of 2018. Atcom Technologies Limited versus YA, Chunawala and Company and others. Having heard the arguments on both sides and perusal of the materials placed before this court, the following points would arise for our consideration: whether the appellant has made out a grounds to interfere with the impugned judgment and decree passed by the trial court. What order or decree? Our finding to the above points are as under. Number 1, negative. Number 2, as for final. You have examined the material placed before this court, including the certified copy of the order sheet pertaining to OS number 64/2019 on the file of the senior civil judge and JMFC Devdurga, placed by the respondent counsel. The plaintiff Somanatha has filed a suit for declaration of possession. Appeal is dismissed. Yes, reasons to follow it.
File hearing matter. Case number 47, Ganesh Nayak.
Bill against conviction.
Case number 47, Ganesh Nayak.
Matters called out. There is no representation for the appellant.
Hello.
In criminal appeal number 20068 of 2014. Stop, list this matter after winter vacation.
One more connected matter is there.
ಅದಕ್ಕೆ ಆ ನಂಬರ್ ಹೇಳಿದ್ದು.
Yes.
Appellant not present in
Yes.
that.
Yes.
Yes.
Seal number 48 RS Siddhapurkar.
Connected.
ಅದ್ರಲ್ಲಿ ಸಪ್ರೇಟ್ ಆಗಿ ಬರಿಬೇಕಾ?
ಅದರಲ್ಲಿ
ಬೇಕಿಲ್ಲ. Yes.
Seal number 48 RS Siddhapurkar.
My lord, appear for the appellant.
Yes.
My lord, this matter, in this writ appeal, we have challenged the order of the learned single judge dated 30th August 2016, page 10 of the appeal papers, my lord.
Yes.
The operative portion of the order your lordship will find at page number 37. At para 25 of the writ petition, the operative portion of the order is there. The writ petition is accordingly allowed and the impugned order of the Land Tribunal Mudde Bihal dated 23/11/2012 is quashed and set aside. Any consequential entry made in the land records in consequence of the impugned order of the Land Tribunal shall be treated as non-est. Further directed peaceful possession of present petitioners in survey number 76, 17 acres, 19 gutters shall not be disturbed by any of the respondent. Costs of rupees 10,000 are imposed on the respondents to be paid to the petitioners within 3 months. My lord, the petitioners before your lordship are respondents 3 to 8 before the learned single judge.
Yes.
My lord, the facts, the detailed set of facts, my lord, which in the writ petition, the petitioners who are now the respondents 1 to 4 before your lordship in this writ appeal,
Yes.
they contended that they were the sons of one Shivaram Navad. The property involves 17 acres, 19 guntas of land in survey number 76 of Mudde Bihal, Bijapur district, which originally belonged to the family of Channabasappa Deshmukh. My lord, somewhere along the way, as I will point out, my lord, there was a change in the law which was not taken into account anywhere in between, resulting in a problem having arisen.
Yes.
My lord, this property was one of the properties included in one suit, special suit number 47 of 1946 for partition. If your lordship sees page 48, my lord, that is the page number 47 in the writ petition facts are mentioned, my lord. Whatever facts I am stating are contained there. From page, the writ petition starts at page number 46.
Yes.
From 47, the facts as I am mentioning are to be found.
Yes.
The 17 acres, 19 guntas in survey number 76 of Mudde Bihal village belong to the family of Channabasappa Deshmukh. Then there was a suit for partition and special suit number 47 of 46 for partition before the civil judge of Bijapur. The suit properties and other properties were taken under the management of a court receiver, one Mr. K.S. Deshpande, advocate, who was appointed on 12/12/1946. Now, the grandfather of the appellants before your lordship, respondents 3 to 8, Kasima Risaldar, took the land for cultivation, Lavani, from the court receiver. On 12/12/1947, the name of Kasima Risaldar was shown as protected tenant for the year 46-47. These are all admitted facts. Then what happens? In the writ petition is stated that within 44 days, that is on 4/2/1948, the name of Risaldar was deleted. And on 26/6/52, Kasima Risaldar was entered as ordinary tenant for the year 1949-50 as per the order of the collector and Mamaltadar. Now, as Kasima Risaldar did not pay the rents, now this is where the problem arises, madam. As Risaldar did not, they say that Risaldar did not pay the rents, he was evicted and possession of the land retaken by the court receiver in 63-64 under the provisions of the Bombay Tenancy and Agricultural Lands Act. My lord, I have given a copy of that act to the court, my lord. This matter had come up earlier. I had given a copy. Lordship, may please see that. This is the crucial portion, my lord. The fact that he did not pay rents and possession was taken in 63-64 is the crucial part because they could not have taken possession. My lord, may please take that act, my lord, Bombay Tenancy and Agricultural Lands Act. I have given a copy to the court, my lord. 2 copies I have given already.
Bombay Tenancy.
ನಾನೇ ಕೊಟ್ಟಿದ್ದೀನಿ 2 ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ. Yes. Section number 32 of that act, Bombay Tenancy and Agricultural Lands Act, section number 32. Your lordship has that, my lord?
Bombay, Maharashtra, two same.
Tenants deemed to have purchased land on Tiller's Day. On the first day of April 1957, the lordship has that, my lord? Section 32.
32 na?
32.
Yes.
Tenants deemed to have purchased land on Tiller's Day. Subsection 1. On the first day of April 1957, hereinafter referred to as Tiller's Day, every tenant shall, subject to the other provisions of this sections and the provisions of the next succeeding sections, be deemed to have purchased from his landlord, free of all encumbrances subsisting thereon, on the said day, the land held by him as tenant, if such tenant is a permanent tenant thereof and cultivates land personally. Such tenant is not a permanent tenant but cultivates land leased personally. The landlord has not given notice of termination of his tenancy under section 31, or notice has been given under section 31, but the landlord has not applied to the Mamlatdar on or before 31st day of March 57 under section 29 for obtaining possession of the land, or the landlord has not terminated his tenancy on any of the grounds specified in section 14, or has so terminated the tenancy but has not applied to the Mamlatdar on or before 31st March 57 under section 29 for obtaining possession of the lands, provided that if an application made by the landlord under section 29 for obtaining possession of the land has been rejected by the Mamlatdar or by the collector in appeal or revision by the Maharashtra Revenue Tribunal, under the provisions that the tenant shall be deemed to have purchased the land on the date on which the final order of rejection is passed. The date of the final order of rejection is passed here referred to as the postponed date. Provided that the tenant of a landlord who is entitled to benefit of proviso subsection 3 shall be deemed to have purchased land on the first day of April 1958 if no separation has taken place. My lord, this was the position. On the first day of April 1957, I became the owner of that property. My lord, the court receiver, I was not liable to pay rents. The problem started there. I've been trying to agitate my rights throughout, but all along this provision has not been taken into account by in any of the proceedings thereafter. 64, 65, 63, 64, he says I was retaken. He could not have retaken for arrears of rent because as on 1st April 57, I became the absolute owner of the property. The landlord had not issued notice to me. Landlord had not evicted me. Nothing has happened. In fact, from the landlord side, Deshmukh's side, nothing happened. Nothing was done. This aspect of the matter has the fact that they took possession from me for rent, 63, 64, yes, is accepted by them. But they themselves say that it was taken under the provisions of the Bombay Tenancy Act. But the same Bombay Tenancy Act provides in section 32 that I am the owner. 57 ನಲ್ಲಿ ಮುಗ್ದೋದ ಮೇಲೆ 63, 64 ನಲ್ಲಿ ಏನು ಮಾಡಕ್ ಆಗ್ತಾ ಇರಲಿಲ್ಲ. Then what happens, my lord? This is a major aspect where then I'll state the other facts also as they have narrated in the petition, my lord. The lands were given to the first petitioner, Lakshmi Narayana Shivaram Navad, for cultivation in 64, 65. So I was in possession. Possession was taken from me and given to the first petitioner. That is the first respondent before your lordship. Then in 66, Risaldar filed a petition before the Land Tribunal under the Bombay Tenancy and Agricultural Lands Act for recovery of possession. Risaldar contended suit was against court receiver and Lakshminarayan Shivaram Nawat that he was filing the case as a dispossessed tenant. He was cultivating the land from 4950 to 63, 64. But even that poor farmer did not know that he had become the owner. Well, this tiller's day, 1st April 1957, that poor farmer did not know that he had become the owner. Well, the statute provided, it does not provided that he would be the owner.
But it is subject to the other provisions.
Yes, I will read all the provisions. I just pointed out, I'll read out all the other provisions.
Yes.
None of the, now, my lord, if my lord goes back to the act, my lord, then my lord, please.
What is the requirement? Is there no such requirement that similar to our Inams Abolition Act or Land Reforms Act, there is no need for filing a form or an application or anything like that?
ಏನು ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಆಕ್ಟ್ ನಲ್ಲಿ ಏನಿಲ್ಲ. Please see this, my lord.
How can it be, sir?
A tenant holds, that's why I was looking through this act. I was surprised to find that this provision is like this.
Yes.
Please see, my lord, section 32 starts. Then.
But it clearly says subject to the other provisions of this section.
Yes. I will take your lordship to the entire, there is no such provision. Like your lordship rightly pointed out, ಅಂತದ್ ಏನು ಇದ್ರಲ್ಲಿ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. ಅದರಿಂದಾನೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು.
Yes, Mr.
This is a 1957 amendment to the Bombay Maharashtra Act.
Correct.
But this is not applicable to the state of Karnataka at all. 1957 to section 32.
57.
ಹೌದು, ಅವ್ರು ಓದಿದ್ದೆ ಅಲ್ಲಿ on the first day of April 1957 ಅಂತ ಹೇಳಿ. In 1957, this act cannot be applied to the territory of Karnataka or Mysore then. So this was never the argument. And Manoj, this is a complete U-turn to the detriment of the interest of the appellant, because the appellant had sought for tenancy rights before the land tribunal, which was granted to him, which is set aside by the learned single judge. Now, if he wants to say, no, I am not a tenant, but a deemed purchaser under some other enactment, then Manoj, he should not have gone before the land tribunal at all.
Yes.
This was never argued before the tribunal, before the single judge, earlier rounds of litigation, nowhere. For the first time, this is being brought here without the permission of the court. Of course, your lordships are hearing the matter, but then permission is required to amend the writ petition or the writ appeal to say that this new ground is to be raised. Otherwise, Manoj, in an appeal, new plea cannot be permitted.
Yes.
Writ petition.
My lord, Adrali, we have made an application for amendment, which is also before your lordship. In 2019, an application for amendment was made.
That's only technical argument ground, Manoj, which I have raised. Assuming that it's a question of law and therefore he can raise it also. How 1957 amendment can be made applicable to the territory of Karnataka?
My lord, then
where is your application for amendment?
Application for amendment was filed on 27/2/2019.
1 of 19, IA 1 of 19.
Not good. ತೋರಿಸಿ ಸೀಲ್ ಇರೋದು ಕಾಪಿ ತೋರಿಸಿ. ನಿಮ್ಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರಾ? ನಿಮ್ಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ ಸಿನಾಪ್ಸಿಸ್ ಅಂತ ಒಂದು ಕೊಟ್ಟಿದ್ದಾರೆ. ಮೇ ಪಾಸ್ ಆನ್ ದಿಸ್.
January 2020.
14 June
2019.
ಇಲ್ಲಿದೆ 27/2/19.
27 to 19.
ಇದರಲ್ಲಿ ಏನು ಬೇರೆ ಬೇರೆ ಪೇಪರ್ಸ್ ಇದೆಯಲ್ರಿ? ಅದ್ರಲ್ಲಿ ಇಲ್ಲ ನೋಡಿ, ಇದ್ರಲ್ಲೆಲ್ಲ ಇದೆ.
ಇದೇ ಒರಿಜಿನಲ್.
ಮುಂಚೆ ಬರ್ಬೇಕು, ಇದಕ್ಕೆ ಮುಂಚೆ ಈ ಅಪ್ಲಿಕೇಶನ್ ಮುಂಚೆ ಬರ್ಬೇಕು. ಇದೆಯಾ? Yes, there is an application.
There is an application.
Adre, it very clearly says that was amended and inserted in the year 1957. When was that?
We didn't have that.
ನೀವು ಓದಿದ provision, section 32. Section 32 was renumbered as subsection 1 thereof by Bombay 15 of 1957. 1957 amendment.
(32A), (32B), (32C), D, E, F have all been done later, my lord.
Correct. 1957.
ಅದು 32 ಇಲ್ಲ, 32A, B, C, D ಅಂತ ಬಂದಿದೆಯಲ್ಲ, ಅದು ಆಮೇಲೆ ಆದಂಗಿದೆ. ಐ ಜಸ್ಟ್ ಚೆಕ್ ಔಟ್ my lord. Anyhow, I will check that out.
ನಮ್ದು ಇದು ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್ ಆಕ್ಟ್
Section 142.
provided that save as other provided in this act, such repeal shall not affect the previous operation of the said enactments or provisions of law or anything duly done or suffered thereunder, or any right, privilege, obligation, or liability acquired, accrued, or incurred under the said enactment or provisions of law. Yes. Yes. Yes, sir, Mr. Senior Counsel.
My lord,
Srivastava.
yes, my lord. My lord, what happens is in 1966, thereafter, I file a petition before the land tribunal. It's again contained at page 49 or 50 of the writ petition, my lord.
Yes.
Then after he had filed this petition, Risaldar passes away and his two sons come on record. The suit was contested by the court receiver and the first petitioner before your lordship. My lord, then what happens is on
Yes.
then on 20 February 1971, the two sons of Risaldar filed a memo withdrawing the suit, saying that they had got into possession through the receiver.
Paragraph 5 ಅಲ್ಲಿ it is said the last 7 or 8 lines. However, in the year 1966, they said Kasima Risaldar.
Yeah, he filed an application before the land tribunal court at Muddebihal. Under the provisions of the Bombay, please see what they have said. Under the provisions of the Bombay Tenancy and Agricultural Lands Act for recovery of possession of the lands. Page number 4950. Yes, ma'am.
Yes.
Because now my learned friend says that the act was not applicable. In fact,
Yes.
it is part of their pleadings itself that application was filed, that the suit was contested by the receiver, by the first petitioner, etc. And thereafter it was withdrawn by a memo dated 22/1971. It was dismissed. And thereafter in 1972, the name of Risaldar, if your lordship sees at page 50, it was deleted. 14/4/1972, the name of Risaldar was deleted, and 68, it is said to have been sold to the first petitioner as per an order in MFA number 300 of 1966.
Yes.
Then, my lord, at page 83, I produced a typed copy. The land was sold to first appellant, the first respondent, in 68, as per the order in MFA. page. My lord, there is one more submission here we would like to make. We have taken up a specific contention that this property was never included in the schedule in the MFA, by which there could have been an order for sale of this property.
No, there is no dispute. Are you disputing this fact that in MFA 300 of 19?
Yes, that's a, please see the writ appeal. My lord, may. Please see the writ appeal, page number 7 of the appeal papers, man.
Page number 7.
Page 7 of the appeal papers, man. Writ appeal, paragraph 10. Learned single judge has not properly considered the fact that the land in question has been sold by the receiver appointed by the court, and as per the order passed in MA 300 of 90, which clearly stipulates that the lands mentioned in Exhibit 224 are permitted to be sold. The said list is not produced to establish the fact that the receiver had the authority to execute the sale deed. Though this fact was very much urged during the course of arguments, the learned single judge has not considered the same and allowed the writ petition on the ground that the sale deed is not challenged by the appellants. And not in the that one issue was there, where we said that it was not part of that MFA 300, the schedule which the court granted to permit, that has never been produced. We had raised objection before the learned single judge. It was not considered. Then, my lord, on 22/9/1975, I filed form number 7.
Yes.
Form number 7, saying that I've been cultivating land from 1944. I'm entitled to be registered. 76, Dastagir Saab filed another form number 7. Both these applications were taken up together, my lord, and the land tribunal, by an order dated 24/10/1981, rejected the claim, the chairman giving a dissenting judgment. The order was set aside by this court in WP number 8044. Again, the order dated rejected the claim on the basis of it. Again, once more it went back to land tribunal. Again rejected on 2/8/1985. Again challenged before this court in WP 29/820. After remand, the fourth respondent, Hamid, categorically admitted, fourth respondent admitted that his grandfather had filed MLT 24/66 and his grandfather's name was entered as ordinary tenant in the revenue records. Before the land tribunal, the second respondent, second petitioner, tendered evidence, and he has produced RTC for 65/66 to 68/69, where his name was shown in the cultivator column as tenant of the land from 69/70 as owned. But these are all the facts, my lord. These are the facts how at one point of time I was shown as I had taken the land on rent. I was shown as a permanent tenant. Then the receiver, I don't know, for some reason they made me an ordinary tenant. Then they removed my name. Then the proceedings continued to. Then I filed proceedings under the Bombay Tenancy Act. It was contested by the receiver, contested by the first respondent. Finally, I withdrew that thing. That is only for the what effect that has. That the only thing is that possibly that act was in force on the date of 1/4/1957. That is the now, my lord. I contended, my lord, specifically I contended before in the statement of objections filed by me before the learned single judge. I specifically contended 17 acres, 19 guntas was not part of special civil suit number 47 of 1946. Lord, I'll- the My lord, the statement of objections is at page number 100 and
No, if you are asserting that fact, then it is for you to prove.
my lord,
If
No,
you are
no,
asserting that
they
fact,
say,
it is for you to prove.
the petitioners say that it was sold. I said it was not part of it. I am saying it is not part of that list. It is for him to
Therefore,
say that.
if you are saying no, it was not part of that order passed in the MFA, then it is for you to prove.
No, he is asserting that it was part of the order. So under one not
Correct.
one, he should have produced that
Consequent
document.
to that, there is a sale deed executed.
My lord, that
Now, if you are contending, no, it was not part of that order in MFA, then it is for you to prove.
we were always under the proceeding on the assumption that he had asserted that it was part of that order, and he withheld the order. He said that they did not produce the schedule to the order which gave the list of properties. That was never produced before any court.
Correct. Now you are saying, no, it was not part of that order passed in MFA. If you are asserting so, then it is for you to prove.
It would be a negative that I am asserting, my lord.
No, sir. Now, if you are taking a stand, no, I have verified it. I find that this was not a part of that schedule in the order passed in the MFA. Then you will have to say so. You will have to produce the document. There is a presumption that can be drawn consequent to that order passed by this court. There is a sale deed executed by the court receiver.
Yes,
in favor of this person.
Yes. Sale deed is executed. We are saying that receiver did not have authority to execute the sale deed.
So therefore, if you are asserting so, it is for you to prove. And you have withdrawn the petition because you thereafter became aware that the provisions of the Bombay tenancy land reforms or whatever, that could not have been asserted by filing a petition before our land tribunal. Our land tribunal
I did not file
to consider the provisions of the Karnataka Land Reforms Act.
No, I did not. Form number 7 was filed under our act. It's not under the Bombay Tenancy Act.
But
earlier to that, my lord, earlier to that, there were proceedings. My lord, earlier to that, in 1966, there were proceedings under the, that is, if your lordship sees page 4950 of the writ petition, the appeal papers.
Yes.
There I have said, Kasi failed to pay, was taken so and so. Thereafter, land was noted to first person so and so. However, they filed a petition before land tribunal for recovery of possession. Subsequent, that last 5 lines of that page 49 gives the details of those proceedings.
It 8-9 lines ali. However, in the year 1966, they said Kasima Risaldar
filed a petition.
MLT number so and so before the land tribunal.
Under the
provisions of the BTAL Act.
My lord, that is their own petition, my lord. It's not this their petition where they say that this was done filed under the BTAL, which means subject to correction and whatever it may be. BTAL Act was in force in that area at that point of time is what I'm trying to make out. That's all, nothing more. But if at all my learned friend can show something which says that that area was excluded, the BTL Act was not in force, well, that ground won't be available to me. Because they themselves have said in their writ petition that this is the act. If if that is filed under that act in 66, 57, I have become the owner.
No. Why we are saying so is because subsequently you withdrew the petition.
Yes, I withdrew the petition.
This may be the ground. That is what we are thinking.
Now I'm not on that. Now I'm
Yes.
not on the withdrawal. Yes, I withdrew the petition. The point remains is, if I withdrew the petition under a mistaken impression of the law, supposing if the BTL Act was applicable and I had become the owner, everything else, my lord, my withdrawal, etc., would have been a mistake. Not knowing. There is no, my lord, there is presumption. Ignorance of law is no excuse, but there's no presumption that everybody knows the law, my lord.
Yes.
That seems to be the.
Yes. Yes, sir.
My lord, actually the appellants before your lordship were in possession of the lands. The way some sort of a plea of waiver or surrender was set up before the learned single judge that needed to have been proved, which was not proved, and the learned single judge held no, you have surrendered everything. It's in the possession of the respondents 1 to 4 before your lordships. That's also a ground which I have made. Well, because I was in possession, where was the valid surrender by me to them for possession? I mean, apart from anything else, no material is placed so that I surrendered the land to them. No valid surrender has been shown. Is also one of the grounds, my lord. The learned single judge does not consider that as a valid argument.
Yes.
My lord, subject to my just verifying and possibly informing the court about the position of this Bombay Agricultural Tenancy Act, I have nothing, no further argument. But all the facts are there. ಇಲ್ಲ ಏನು ಇರೋದೇ ಅಷ್ಟು.
ಅದೇ
ನಮ್ಗೆ ಇರೋದೇ ಅಷ್ಟು. ಎರಡು ಫ್ಯಾಕ್ಟ್ ಇದೆ. They claim surrender. There is no valid proof of surrender. ಎರಡನೇದು this BTAL Act, ಅದು ಒಂದ್ಸತಿ ನೋಡ್ಬಿಡ್ತೀನಿ. I'm not able to locate anything which says that it was repealed as in its operation to that area. I'm not able to get, because Land Reforms Act ನಲ್ಲಿ section 1
saving clause
ಹೇಳ್ತಾರೆ.
ಅದೇ ನಾನು
that is
learned senior counsel on the other side.
The Land Reforms Act
and I have read it out.
The Land Reforms Act came in 1961.
Any right, privilege.
But the issue is like this. In this case, there are 3 grounds on which the appellant is ousted. One is that he was not a tenant at all. Secondly, tenant as on the date of the appointed day under the Karnataka Land Reforms Act. He was not a tenant. He was not in possession also
Date?
of the Karnataka Mysore Land Reforms Act. Under the Karnataka Land Reforms
What is
Act.
the appointed date?
That is not 1974, 1/3/1974.
1/3/1974.
74.
Yes.
Neither he was a tenant, nor was he in actual possession of the property at all, because kindly see annexure J. Page number 96, the typed copy at page 98. I will also answer that the legal argument regarding the application of Bombay Act. This annexure J, page 96, is an order sheet dated 20th of February 1971.
Yes.
Pleader for the petitioner present, PRD R2 and R3. He filed memo, heard the pleaders who were representing respondent and the respondent dead. Shri so and so for R3 press for cause in view of memo of pursis. That's a term which is used in Bombay High Court even now, of the pursis of the It is dismissed. Ultimately, it is dismissed. That this, my lords, can be understood by reading.
Type copy ಇದೆ ನೋಡಿ 98.
ಅದೇ 98. ಅಷ್ಟೇ ಅವರು ಟೈಪ್ ದಲ್ಲೂ ಹಂಗೆ ಬರೆದಿದ್ದಾರೆ.
Hmm.
But that is in continuation of Annexure H. Annexure H is a document which is filed by the appellants, which say, this is, my lords will see at page number 93.
Hmm.
This is Kashim Mruta Varasudararu versus K.S. Deshpande. Kashim Sa is the original appellant.
ಮುನ್ಸಿಪ್ ಕೋರ್ಟ್.
ಹೌದು.
Huh?
ಹೌದು. RPC number 2 of 1970 ಅಂತೇಳಿ. That is for the recovery of possession and everything. Ultimately, in the third paragraph, ಇಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಸದರಿ ಅರ್ಜಿ ನಂಬರ್ನೇದವರ ತಂದೆ ಕಾಶಿಂ ಸಾ ಲಾಡ್ಲೆ ಸಾ ರಿಸಾಲ್ದಾರ್ ಈತನು ಈ ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದು ಅದೇ. ಅವನು ಮೃತ ಆದ ನಂತರ ನಾವೆಲ್ಲರೂ ವಾರಸ್ದಾರರು ಇದ್ದು ಆ ಪ್ರಕಾರ ನಮೂದು ಆಗಿದೆ. ವಿಜಾಪುರ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಕೇಶಾಪುರ್ ಇಸ್ಟೇಟ್ ದ ಬಗ್ಗೆ ಸ್ಪೆಷಲ್ ಅಪೀಲ್ ಸಂಖ್ಯೆ 47 of 46. This also is very important. This is 1946 in which that K.S. Deshpande is appointed as a receiver of the court. And these lands were under the receiver. Through the receiver, the original appellant alleged that he was in possession. And that was 1946. The amendment to Bombay Act is of the year 1957. So it was 1946, the act was applicable. And proceedings under that act continued until further certain time. But not 1957 amendment to section 32 will be applicable to the entire scenario. Even assuming that 1957 act is made applicable, section 88 capital B, clause D of this Bombay Act will say, which is almost in parameteria, I may say in part, with section 108 of the Karnataka Land Reforms Act, which says that any person who is alleging to be as a tenant under a receiver, the entire the provisions will not be applicable to him. I have to be a tenant under a landlord, not under the civil court or under a receiver of the court. If I'm alleged to be a tenant under a receiver, then there is no question of grant of the.
ಅಲ್ಲ, there is an express provision ಅಂತ ಹೇಳ್ತಾರೆ. Section 88 of
88 capital B of the Bombay Act, this very act.
88 capital B.
Yes.
And there is a similar provision in the Karnataka land.
One part of 88B clause D is almost parameteria with section 108 or similar, if I may not say use the word parameteria, but it is similar to section 108 of the Karnataka Land Reforms Act. My lord is holding that yellow book, my lord, in that section 88 capital B, I don't know whether it's available. My lords will see page number 91, 91. Nothing in the foregoing provisions except sections 3, 4B, 8, 9, 9A, 9B, 9C, 10, 10A, 11, 13, and 27, and the provisions of chapter 6 and 7. If I'm not wrong, my lord, section 32 is under under chapter 3, not under 6 and 7. In so far as the provisions of the said chapters are applicable to any of the matters referred to in this section mentioned above, shall apply A, to lands held or leased by a local authority or university established by law in Bombay area of the state of Maharashtra, and B, to lands which are the property of a trust for an educational purpose, a hospital, Panjar Pole, Gaushala, or an institution for public religious worship, provided that such trust, I will skip that, my lords. B, I will come to C.
Yes.
To lands assigned or donated by any person before the first day of August 56 for the purpose of rendering any of the following services useful to the community, namely maintenance of so and so, so and so. Then D, this is important.
Yes.
To lands taken under management temporarily by the civil, revenue, or criminal courts by themselves or through receivers appointed by them till the decision of the title of the rightful holders, provided that from the date on which the land referred to in clause D is released from management, all the foregoing provisions of this act shall apply thereto, but subject to the modifications that in the case of a tenancy not being a permanent tenancy, which on that date subsists in the land, landlord shall be entitled to terminate the tenancy under section 31 or under section 33B in the case of a certificated landlord within 1 year from such date, and within 1 year from the expiry of the period during which the landlord or certificated landlord is.
Sir, he has made a clear statement that he started cultivation with the approval of the court receiver.
Yes, yes. And that is what Annexure H. Annexure H is the very same thing, my lords, which he says, I was a tenant under the court receiver and I have surrendered the possession itself to the receiver now. My tenancy having ended long ago. So tenancy ends earlier and possession is actually recovered in 1971. Order sheet is dated 1971 February. Annexure H.
One not.
Section 108 of the Karnataka Land Reforms Act.
Ah.
108 says, lands taken under management of Court of Wards, subject to the provisions of Section 110, nothing in the provisions of this Act except Section 8 shall apply to lands taken under the management of the Court of Wards or of a government officer appointed in his official capacity as a guardian under the Guardians and Wards Act 1890, or to the lands taken under management temporarily by the civil, revenue, or criminal courts by themselves or through the receivers appointed by them during the period of such management. Provided that in case of tenancy subsisting on the date of taking over the management, provisions of Section 44 shall apply and the land shall vest in the government. Almost, it's not perimeter, but this part of the provision is equivalent to Section 88B.
Yes.
Now, whatever the case may be, even if it is Bombay, the Tenancy Act, which is applicable, in 1957, if he had alleged that he had become a deemed purchaser of the land, which is subject to other provisions of that act, where he has to get a certificate from the tribunal in Maharashtra also, in Bombay state. After the tribunal determines the purchase price and so many other formalities have to be followed. So merely reading one provision, Section 32, and saying that I become a deemed owner because I was tenant then, would also not be sufficient, assuming that Section 88B also should not be made applicable.
Yes.
My lords, read para 5 of the order of the learned single judge. Just before that, my lords, the date of appointment of receiver is mentioned. That is in page 15, 1-5.
Yes.
Just at the end of that paragraph before para 5. The said receiver, Mr. K.S. Deshpande, advocate, was appointed as receiver by the court on 12/12/1946. And then, my lords, the facts are narrated further. There was agreement between the tenant Qasim Shah and the receiver in the appeal case number 154 of 1959 of Bijapur District Court, and the tenancy rights of late Qasim Shah were waived in appeal case number 47 of 1946 of Deshmukh family estate, which was settled before the Honorable Supreme Court. And the reference to this memoir pursis, which they call it, at annexure H, that is also found in the order of the learned single judge in paragraph number 19, page number 30, ink page 30. Internal page 21 of the judgment. It is running page 30.
Yes.
Para 19. It appears to this court that the respondent Land Tribunal Mudde Bihar, while passing the impugned order at Annexure A on 23/11/12, has completely missed to notice the effect of the earlier proceedings before the Land Tribunal Mudde Bihar Bijapur in MLT number 24 of 1966 and RPC number 2 of 1970, in which the predecessors of the present respondents had clearly waived their rights of tenancy upon a compromise entered with the opposite party, namely the receiver, Mr. K.S. Deshpande, of the said entire chunk of land known as Deshmukh Family Estate, and a memo or purchase annexure A H was filed by them, having accepted the consideration of rupees 2,000 for forfeiting their rights whatsoever in the said land, and on the basis of that alone, the compromise decree was passed by the Land Tribunal in RPC number 2 of 1970 on 20/2/1971. That is annexure J, which I pointed out to you. That compromise decree, in fact, clinches the issue and fait accompli of the present respondents who were stopped from raising a dispute and stake their claim through their predecessors, though their predecessors had already waived their rights of tenancy in the present case. Despite this, it appears they not only repeatedly approached the tribunal on one or more occasions, but they failed there, and even before this court has noticed about, matter was only remanded back to the tribunal.
Yes.
Now, my lords, about the other argument which is made is that there is no list of properties shown in that order of the.
No. That we are saying it is for them. If they are raising that contention, it is for them to prove.
But the my sale deed refers to that very order of the High Court.
One submission.
But still, but they are still making that statement. So therefore, we are saying
They have to.
if you are saying so, then it is for you to prove.
But
You
one
can't make a statement and call on the other side to come and get the document. Not possible.
My
May I
lord,
read
one
that
submission.
purchase- may I read that purchase, my lord, which
What my
closes
learned
the entire
friend
issue.
saying.
Whether they are the owners, deemed owners, or whatever, they have waived everything at page 95, the typed copy of annexure H. That will resolve, my lords, all the on facts they cannot speak at all now.
And there is some statement that it was done before the Honorable Supreme Court.
How do that MSA, the suits between that Deshmukh family, where K.S. Deshpande was the receiver, that ultimately ended in the Supreme Court also. That's the statement.
Yeah, copy of that is also available here.
I think it was, my lords, while arguing before the learned single judgment, I will have to verify. I cannot make a statement right way, but it was. I will just verify and make a submission.
Yes.
My lord, one submission, my lord.
One
Subject to correction.
One nimsha. Page 95.
Yes, 95 annexure H.
Ah.
This reads, is the typed copy, my lord. There must be some error in that, but then it says, my lords, this is between Kashim Saab versus K.S. Deshpande. ಇದರಲ್ಲಿ ಅರ್ಜಿದಾರರ ಶಿಫಾರಸು
annexure H.
ಅದೇ annexure H. ಇದರಲ್ಲಿ ಪ್ಯಾರಾ 3 is important.
Yes.
ಸದರ ತಂಟೆದ ಜಮೀನನ್ನು ನಮ್ಮ ತಂದೆ ಕಾಶಿಂ ಸಾಬ್ ಸದರಿ ರಿಸೀವರ್ ಕಡೆಯಿಂದ ರೈತ ಅಂತ ಸಾಗ ಮಾಡುತ್ತಾ ಬಂದಿದ್ದ. Now this is the most vital admission.
So it was never with the original owner.
It was never tenanted under the landlord.
Correct.
Now 32 of the Bombay Act also will not be applicable if the tenancy is not under the landlord but under the receiver.
Yes.
ರಿಸೀವರರು ಕೋರ್ಟ್ನ ಹುಕುಂ ಪ್ರಕಾರ ಅದರ ಕಬ್ಜಾ ತಗೊಳ್ಳುವ ಪೂರ್ವದಲ್ಲಿ ಸದರಿ ಕಾಶಿಂ ಸಾಬ್ ತಂಟೆದ ಜಮೀನವನ್ನು ರೈತ ಅಂತ ಎಂದು ಸಾಗ ಮಾಡಿದ್ದಿಲ್ಲ. ಮುಂದೆ ಸದರಿ ಕಾಶಿಂ ಸಾಬ್ ವಕ್ತಶೀರ್ ಲಾವಣಿ, ವಕ್ತಶೀರ್ ಅಂದ್ರೆ ಟೈಮ್ಲಿ, ವಕ್ತಶೀರ್ ಲಾವಣಿ ಕೊಡದ ಮೂಲಕ ಕಾಯ್ದೆಶೀರ್ ಕ್ರಮ ತಗೊಂಡು ಸದರಿ ಕಾಶಿಂ ಸಾಬ್ ಕಡೆಯಿಂದ ತಂಟೆದ ಜಮೀನದ ಕಬ್ಜಾ ಕಾಯ್ದೆಶೀರ್ ತಗೊಂಡಿರುತ್ತಾರೆ. ಮುಂದೆ, that is, he did not even pay that whatever rent was required to be paid to the receiver. So accordingly, ಮುಂದೆ ರಿಸೀವರರು ಎದುರುದಾರರಾದ ಲಕ್ಷ್ಮೀನಾರಾಯಣ್ ಶಿವರಾಮ್ ನಾವಡ್ ಇವರಿಗೆ 4 ಅರ್ಜಿದಾರರ ಈ ಅರ್ಜಿ ಮೈಸೂರು ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್ ಕಾಯ್ದೆಯ ಪ್ರಕಾರ ನಡೆಯುವುದಿಲ್ಲ. ಈ ಅರ್ಜಿದಾರರು ಸದರಿ ಜಮೀನಿಗೆ ರೈತವಿರುವುದಿಲ್ಲ. 5 ಅರ್ಜಿದಾರರು ಹೇಳಿಕೊಂಡಿದ್ದರಿಂದ ಮತ್ತು ನ್ಯಾಯ ಉಳಬಾರದಂತ ಅರ್ಜಿದಾರರಿಗೆ 2,000 ರೂಪಾಯಿಗಳನ್ನು ಮೊದಲೇ ಕೊಟ್ಟಿದ್ದು ಮುಟ್ಟಿರುತ್ತದೆ. ಕಾರಣ ಸದರಿ ಅರ್ಜಿ ನಡೆಸುವುದಿಲ್ಲ.
Yes.
And before this, my lords, the date on which the tenancy is alleged to have been created, my lords, in 1946, the receiver is appointed. 1949-50, Kashim Shah Risaldar alleges that he has taken this on cultivation from the receiver, court receiver, as ordinary tenant. Sada Kula Anteli. 26/6/1952, he alleges that the revenue records showed that the tenancy was entered in the name of Risaldar as Sada Kula. Then 1963-64, possession of the land is taken back from Kashim Saab for failure to pay the rental by the court receiver. This was challenged by the authority, the other side. And 1964-65 land is leased in favor of this Lakshminarayan Shivaram Nawad by the court receiver. And thereafter in 1966, the Qasim Saab, he files this MLT 24 of 1966 for recovery of possession. So he had lost the possession much prior to 1966 itself. And then, my lords, after filing the petition for restoration of possession, he dies and the LRs come on record, and they then finally give this memo before that RPC number case in 1971. Sailed it in favor of Lakshminarayan Shivaram Nawad is pursuant to the High Court order in MFA 300 of 1966 on 18/10/1968. Even on that ground also, my lords, 1/3/1974 is the appointed date under the Karnataka Land Reforms Act. Even on that day, much prior thereto, there was a sale deed in favor of the purchase.
Yes, yes, Mr. Srivatsa.
My lord, if I may say, add one more thing, my lord, subject to
Yes.
correction. Am I audible, my lord?
Yes, yes.
My lord, section 88B, clause D, which my learned friend read to say that where lands were taken under the management temporarily by civil revenue criminal courts.
Yes.
That amendment, my lord, according to the book which I have, subject to correction, that's why my lordship may see it in your lordship's book or in the library. It says it was inserted in 1961. That specific provision regarding receivers was in 1961. It says by Maharashtra 9 of 1961, section 35. Is what I have here. I'm not very clear about the authenticity.
ಇದರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ, section 88A1 was inserted by Bombay Act 63 of 1958.
ಹೌದು.
Section 88B was renumbered as subsection 1.
Yes.
Of that section, and subsection 2 was inserted by Bombay 38 of 1957 Act.
Yes. My lord, then come down to clause D. Clause C was added by Bombay Act 63 of 1958.
Yes, yes.
Then clause D was inserted by Maharashtra 9 of 1961.
Correct.
So, my lord, therefore, as on 1/4/1957, this restriction was not there. This is all I wanted to point out, because my learned friend pointed out, I was reading this, subject to whatever, because a lot of these books, some error, or maybe the gazette has to be seen to see that the correct date is.
No, see, those dates may not become relevant, because when did you take the land on tenancy from the court receiver?
I took
You have made a clear statement. That is probably in the year 1946
Well, I
is
tell
the
you,
receiver appointment
49. I took it.
4950.
ಇವ್ರು ತಗೊಂಡಿದ್ದು.
ನಾನು ತಗೊಂಡಿದ್ದು, I'll say, took somewhere in 1940.
4950.
46. Your lordship may see their writ petition. Please see page number, what they have said in the writ petition. Page 48 of the writ petition. I mean, of that appeal memo. ಅಲ್ಲಿ ಅವ್ರು ಹೇಳ್ಕೊಂಡ್ ಬರ್ತಾರೆ, please see paragraph number 4. The grandfather of respondents 4 to 8, namely Qasim Sir Isaldar, took the land in dispute for cultivation from
somewhere in the year 1946-47.
46-47, somewhere along that way, has taken it on. So my submission is, if the amendment has come in 61, then I'm still protected by it to a certain extent, is my submission. I mean, I don't know the date, because that copies which we have, I find that it's different books, there are different dates. That needs to be verified. If at all is the argument appeals to your lordship, the date may also be considered. Ashte Swaminani, I have no further arguments.
All right. We'll consider. Anything more?
Well, it's that also, my lords, if subject to what is the exact date of amendment, there are two arguments that I can make, my lords, on law. One is, if there is an insertion of clause D also assuming. This insertion has to be read once. The entire section 88B is inserted in the year 1957.
Yes.
And then this 88B1 is made as subsection 1. And thereafter, my lords, clause D is also an insertion later on. So if it is inserted, my lords, it goes back to the date of the original provision being inserted in the enactment. So this clause D being inserted subsequently or whatever date would not, my lords, take away the rigor of that very provision. And few judicial literature which I was able to read, my lords, shows. I have to, my lords, then go to all the judgments of Bombay High Court. There has been a long line of decisions from 1940s till 1980s where this section 32 has been interpreted so many times by the larger bench of Bombay High Court. Ultimately, there is some meaning given, interpretation given to section 32 also. But this, my lords, the rigor that so far as trust is also one which is mentioned in section 88B. So trust property is not within the provisions of that chapter 3. This has been held by the Bombay High Court consistently, even before this 1980 also. So what I assume is, that this
property originally belonged to a trust, is it?
It belonged to Deshmukh family.
Sorry.
Why I'm referring to trust is because this provision 88B is interpreted even before this 1961 also. So, my lords, there could have been some corresponding provision before it was renumbered as clause D and Tastelon. I will also make some research whether clause D had some corresponding provision before 1961.
All this arose only because they have filed an application for amendment
now
and sought to bring in this new angle.
Yes.
Otherwise, it was not necessary. The finding of the tribunal and the learned single judge is on this ground that voluntarily they have given up, they have entered into a compromise and gave up their rights before a court of law.
Yes.
Which has been recorded. And
that I said, but there's no presumption that everybody knows the law. Ignorance of the law is no excuse, but there's no presumption that I knew the law. Tenants, tillers, the yellow,
Allah, that is different. Now, consciously before a court of law, if a party has entered into a compromise and received some money and given up the rights.
No, that is what. That is when they say surrender. That surrender is not proved by
that has happened before a court of law.
The petitioners the respondents 1 to 4 have not been able to show surrender properly. That's also one of the grounds which I have raised in the appeal. That may also have to be considered. I leave it to your lordship. I don't want to take your lordship further time.
Their remedy, my lords, for this argument, the remedy is to challenge that order sheet of the year 1971. They cannot come before the land tribunal saying that give me the land as tenant now. They cannot even argue that point here.
All right. Good. Reserved.
Great.